This Council resumes the second reading debate on the Protection of Critical Infrastructures Computer Systems Bill. Ms. Carmen Khan, Chairperson of the Bills Committee on the bill, will first address the Council on the committee's report. Ms. Carmen Khan. Madam Deputy, as the Chairperson of the Bills Committee on the Protection of Critical Infrastructures Computer Systems Bill, I now report on the highlights of the BC's deliberations. The bill seeks to impose statutory requirements on designated critical infrastructure operators or CI operators in line with the practice in other jurisdictions to ensure that these operators take appropriate measures to protect their critical computer systems so that essential services or critical socio-economic activities are less likely to be disrupted or compromised by, for example, cyber attacks, thereby enhancing Hong Kong's overall resilience against potential risks. The Bills Committee held 4 meetings with the administration, spent 17 hours on the discussions, and received 18 submissions. Critical infrastructures, or CIs, meant 1. Infrastructure for the continued provision of essential services in Hong Kong in 8 specified sectors: energy, information technology, banking and financial services, land, sea and air transport, healthcare services, telecommunications and broadcasting services. And 2. Infrastructure, crucial to sustaining vital socio-economic activities. The bill imposed 3 types of statutory obligations on CI operators: 1. Organizational setup, 2. Preventive steps, and 3. Incident reporting and response to protect the computer systems necessary for the core functions of a CI accessed in or from Hong Kong. Members raised various concerns and shared views on how to ensure effective implementation of the proposed legislative framework. The bill proposed a Commissioner of CI Computer System Security to be appointed by the Chief Executive. Members agreed that the organizational and preventive responsibilities for regulating each sector should rest with its statutory sectoral regulator. This practice, also found in the laws of the United Kingdom and Australia, was set out in the bill as the designated authority. Such authority would work with the Commissioner as the regulating authorities, whose functions included identifying CIs, specifying CI operators, designating critical computer systems, and issuing codes of practice. The bill only proposed specifying the Monetary Authority and the Communications Authority as the designated authorities for monitoring the compliance of the regulated organizations in their respective sectors. On this point, members requested the administration to review the list of designated authorities and the types of regulated organizations as early as possible, and to specify other statutory sectoral regulators as designated authorities, or name the Commissioner as a regulating authority where appropriate. This would help industry prepare early on. As Hong Kong was an international financial center, members also explored with the administration the designation of certain financial infrastructures closely linked to people's lives or crucial to the economy, such as the Central Clearing and Settlement System and the eMPF platform, as critical computer systems. The administration confirmed that it would keep the 2 broad categories of CI under review and put more systems under these groups as appropriate after the passage of the bill. Members also requested the administration to ensure coordinated efforts between the Commissioner and the designated authorities to avoid duplication of regulation. Members welcomed the bill's empowerment of the Secretary for Security to make regulations for the better carrying out of the provisions of the bill and to amend by notice in the Gazette any schedule, including the designated authorities and regulated organizations specified in Schedule 2 to the bill. At members' suggestion, the administration would later move an amendment to add a provision to the bill, spelling out the overall monitoring role of the Secretary for Security over the regulating authorities. Madam Deputy, on regulation, as the bill would not apply to the government, members argued for administrative measures to ensure the security of computer systems under the purview of bureaus and departments which were essential for the proper functioning of the community. The bill would only apply to CI operators. The administration said that in response to industry feedback, an operator would not be required to give notice of changes in the ownership of the CI. On this matter, members noted that if the owner appeared to be in control of the operation and management of the CI, it was possible that they may be designated as the operator and be subject to statutory obligations. The administration advised that it would identify CIs and designate operators and specify critical computer systems in phases based on risk assessment and the readiness of organizations. Members learned that if the bill was passed in the first half of 2025, the administration's aim was to set up the Commissioner's office within a year of the bill's passage and then designate the CI operators in phases within 6 months of setting up that office. The bill proposed keeping the names of regulated CIs and their operators secret to prevent them from being targeted by attacks in line with the practice in the UK and Australia. Members had no objection to this approach, though they were concerned about the criminal liability of someone who disclosed the information without lawful authority. The administration responded that the issue could be dealt with under the existing law. On the code of practice, members said that in preparing these codes, regulating authorities should consider the latest technology and international standards and draw up sector-specific codes based on the circumstances and needs of various sectors after fully consulting stakeholders. Members also made multiple suggestions on the provisions on statutory obligations to reflect more accurately the administration's policy intent and incorporate industry feedback, such as the requirement for operators to maintain a continuous physical presence in Hong Kong for running their business. Such comments were adopted by the administration. In addition, members were pleased to note that the bill provided for an independent appeal mechanism whereby a body may appeal to the appeal board against certain decisions made by a regulating authority. Other jurisdictions, such as the US and the UK, did not have a similar mechanism in place. Under the bill, decisions made by the appeal board would be final. An outfit affected by such a decision could seek judicial review. In response to inquiries and investigations into computer system security threatened incidents and investigation of crimes, the Commissioner may require a CI operator to produce relevant information available to them in or from Hong Kong. Given this and the bill's lack of extraterritorial effect in enforcement, members wondered how a CI operator could ensure compliance of an out-of-town third-party service provider with the bill's requirements. The administration explained that the regulating authorities would provide guidelines and contract templates in the code of practice for operators to follow when engaging such services. Guidance would also be given on the measures that operators should put in place to ensure the security of data stored overseas. In addition, the bill also provided certain safeguards, such that an authorized officer exercising certain investigation powers under the bill, including the production of information against an organization other than a CI operator, would need a warrant from a magistrate before doing so. Members agreed that the offenses and penalties arising from non-compliance with the obligations and the requirements under the bill should only be imposed on organizations, and that the penalties should consist of fines only, including extra daily fines for continuing offenses. The administration also drew members' attention to the fact that operators would not be able to point to the clash of this bill's requirements with the laws of other places as a reason for not following the bill's provisions or as a reasonable excuse and cite it as a defense for non-compliance. Finally, at members' suggestion, the Secretary for Security would allay the concerns of some stakeholders by making it clear in his speech for resuming the second reading debate on the bill later on the purpose of imposing statutory obligations on CI operators was to ensure the security of critical computer systems instead of targeting the personal data or trade secrets within those systems. The administration will also move amendments in response to members' other comments afterwards. The BC supports such amendments. Madam Deputy, now I share my own thoughts on the bill. In February 2022, we had a debate on the policy address. I argued for legislating to protect our critical computer systems. The necessity lied in the fact that back in 2021, our country launched its own bill on this front, and in other places, the UK, Singapore, Macau, SAR, and EU, those places enacted their own laws between 2018 and 2022. Failure to enact on our side means we fall behind the curve and we are at a disadvantage. President Xi Jinping proposed the holistic approach to national security 11 years ago, and that approach covers more than 20 interrelated areas. He also argued for coordinating between development and security. At the two sessions this year, the stress was also placed on the healthy interaction between development and security. With more risks, it becomes even more important that we step up our capabilities. And in recent years, we have seen many cyber incidents. A certain software provider had this blue screen of death, and there were wide-ranging implications. Many businesses suffered huge losses. Now, for the Fortune 1000 businesses, the losses totaled more than $5 billion, and there are still litigation going on. Locally, 2023, Cyberport was attacked by ransomware. More than 13,000 data subjects and 400 gigabytes of data were locked. And then we also had a hospital targeted by a hacker. Last year, some users were affected. That shows the risks are there for our critical systems. When something goes wrong for our energy systems, transport system, or financial infrastructure, the consequences will be dire. And that's why we need this legislation. And now come to some matters of concern. First, guarding against the risks to our financial systems, we are an IFC. As of February this year, 175 institutions could operate safely because of our robust financial infrastructure. Our Central Money Markets Unit, or CMU, sees a daily transaction of $30 billion. And there are more than 16 million users on our faster payment system. We also have the CLP credit referencing platform. There are also credit referencing agencies. All these bodies have data online. We also have the CCASS. And we also have the eMPF platform with data on workers and employees. All workers will see their MPF migrated to that platform by the end of this year. So the security of our financial systems is crucial to our development. So the government should take this risk-based approach in designated critical systems as critical infrastructure. And those operators should be subject to scrutiny either by the commissioner or the regulating authorities. The government will be out of scope for this regime. I had my concerns, but then the government reassured us that the Digital Policy Office had prepared policies and guidelines for department. The DPO also pledged to look at the latest national standards and international standards in preparing those guidelines. But we do know that even government agencies had its own share of cyber incidents. In 2024, the EMSD, URFSD, they used third-party services, they got into problems. And last month, Invest Hong Kong also fell victim to a cyber attack. So here, I want to remind the authorities and the DPO in particular, we should require those departments to protect not just their own critical computer systems, but also be proactive in monitoring their contractors to ensure their compliance with the statutory obligations. Say, something goes wrong with the system of an airline. The commissioner, the airport authority, and the airlines and the civil aviation department must respond swiftly to minimize the impact. Now, on extraterritorial effect and data, we're an international city. Data should flow freely. So we don't require operators to store data locally. This bill comes with no extraterritorial effect. So the Commissioner will not be able to enforce the law outside Hong Kong, but we can designate a computer system accessed in or from Hong Kong as a critical system. So there is a proper balance struck under this bill. Now, on the conflict of laws, what if this bill's requirements clash with the laws of other places? The administration said a CI operator cannot cite that as a reason for not complying with this law, or cite that as a reasonable excuse as a defense for non-compliance. I fully support the administration's explanation. Indeed, operators should follow all the laws here. Now, on change of ownership for CIs, this bill only targets operators, but changes in the ownership is out of scope. So let's look at the 8 sectors. For some of them, the law already governs the change of ownership for some areas, such as Cap 155 that covers changes in the controlling interests of banks, and then Cap 106 telecommunications ordinance on changes in license holders. But then critical infrastructures are vital to our socio-economic activities and also they matter to our financial security. So on change of ownership, we should be constantly reviewing our laws and regulations to see if we can do better. Now, on the commissioner's power, some wonder if this commissioner will have too much power in their hands. Now, on accessing information, unless it's about a CI operator, otherwise that commissioner will have to ask a magistrate for a warrant before proceeding. If it's about entering the premises, a warrant is needed. Based on the government's information, let's look at other jurisdictions, Singapore, Australia. In those places, no warrant is needed for investigations in those places. The devil is in the details. The code of practice will not be subsidiary legislation. But we have to be mindful of the code of practice when we are deciding whether an operator is falling short of the requirements. If something isn't right, a written reminder can be sent to the operators. Failure to follow those instructions can be an offense. So, the code of practice will make a difference. The administration has already shared a skeleton version of the code, so those codes should be subject to constant review and they should move with the times and be effective. The security of our critical infrastructures is crucial to our stability, prosperity, and development. I hope that with the bill's passage, we will be able to truly implement every aspect of the holistic approach to national security so that we can safeguard our journey as we go from stability to prosperity. I support the bill.
Mr. Ambrose Lam. Madam Deputy, Presidency said that security and development should go hand in hand and that both are essential. And only when security is guaranteed will we be able to have sustainable development. Nowadays, the operation of critical infrastructures relies heavily on computer systems and internet, as well as smart devices. They become more and more vulnerable. In the event of cyber attacks and suspension of the internet, we won't be able to make calls, place bids for the stock market, transfer sums of monies, and the society as a whole will come to a standstill. That is why I support the SAR government in enacting legislation to protect critical infrastructures. The operators of critical infrastructures, or CIOs, should ensure security of their critical computer systems. They should also regularly submit reports and conduct security checks to make sure that they are resilient against cyber attacks. They should also report incidents to the government, but I still think that there is more to be desired for this bill. First and foremost, are there ways for us to investigate into the hacking activities that may compromise our cybersecurity? Can we classify these hackers as terrorists? According to the government statistics, in terms of cybersecurity incidents in Hong Kong, there was a sudden surge in a short period of time. In 2023, 7,752 incidents were recorded. In 2024, it rose substantially to 11,333, up by close to 50%. And we should be alarmed by this rise. We should find out why. Has Hong Kong become the target of global hackers? Are the cybersecurity measures outdated? These are questions we need to mull over. Another point is, when nowadays cybersecurity incidents become so prevalent, do we have any contingency plan? At the Bills Committee meetings, I raised the following question. The Commissioner might be able to demand remedial measures to be taken by CIOs, but there is no provision on the Commissioner's direct takeover of the system being attacked. All the bill requires is for the CIOs to report incidents to the government. And after raising hue and cry, there is no other option, because the CIO could refuse intervention by the government. So even when the problem is glaring, the government has no right to take over the operation of the CCS of the CIO. This could be catastrophic. I suggest that another consultation be conducted for the government to be able to intervene and minimize the adverse impact. Now, the next point is this. In 2018, a German brand vehicle used cruise control in the country. It was traveling at speed 120 kilometers per hour. However, the cruise control went out of order when the driver tried to decelerate. So a call was made to the Chinese headquarters of the vehicle company. The car traveled all the way from Henan to Shanxi, and it was like the real version of Speed, the Hollywood movie. Ultimately, they had to contact the German headquarters in order to stop the cruise control so that the vehicle could brake in time. Of course, the German car company rejected the allegation that the headquarters could intervene with the technology of the car. But in fact, the technology existed long ago in 2009. According to the Automobile Security Act in the United States, there is a system that would allow the authority to track the stolen vehicle. Nowadays, a motor vehicle is no longer just a means of transport. It is a highly digitized, smart device. It's part of the Internet of Things. Many e-vehicles have autonomous driving modes, and that the software could be updated remotely. The car doors or even the whole engine could be switched on through the use of an app. You can also operate the car to park automatically with the phone app. And if something goes wrong with the system, for some particular brands, you can have the tele-consultation service for servicing and repair to be done remotely without having to visit the garage. Now, these are really convenient technologies, but there are two sides of the coin, because likewise, the system could be hacked, and that could cause a cybersecurity threat. Imagine, for a vehicle with smart system, if it's under the attack of hackers, then the vehicle could be controlled in terms of the speed, the direction, even the braking device. It could threaten or endanger the lives of passengers, not to mention other road users. It could lead to serious traffic accidents. Now, if inside this vehicle we have some tycoon or leaders, and that if the criminals could control the cars, and it could cause collisions and the whole city could be paralyzed, it could be catastrophic. So I think that smart vehicles should also, or at least the system controlling the smart vehicles, should be designated critical computer systems, because their security directly impacts on stability of our whole society. All smart vehicles on sale in Hong Kong should meet the cybersecurity standards. They should also be subject to regular checks to make sure that security loopholes are plugged. The SCR government should also work with the car makers so that a system can be set up for problems to be dealt with as soon as possible. On the whole, we are relying too much on computer systems and smart technologies. This is an inevitable trend. But at the same time, we should manage risks properly to make sure that it will not threaten the stability of society. Protection of Critical Infrastructure Computer Systems Bill is a good start. This can help us tackle future challenges. I fully support this bill, and I hope that the government could further improve the provisions so as to support high quality development with better provisions that could secure our computer systems. Now, technological advancements are taking place very rapidly, and there are still security loopholes. I hope that the government could start another consultation to enhance protection. Mr. Chen Sil-hung, I am a senior advisor to CLP. That's my declaration of interest. I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. As our society becomes digitized, we rely more and more on computer systems, the internet, for all operations. Now, it is crucial that we enact legislation to protect critical infrastructures and their computer systems so as to enhance our resilience. Now, 1 year ago today, this council was examining the Safeguarding National Security Ordinance. And as a member of the Bills Committee, I was concerned about sabotaging activities, and that I believe they should include activities that undermine or disrupt the public infrastructure like computer systems or other electronic systems. Now, under this bill, CIOs are obliged to set up dedicated management units and draw up emergency response plan to protect the critical computer systems that are under their purview. And there are a number of areas. First, in terms of the 8 sectors such as energy, R&T, banking and financial services, air, maritime, land transport, healthcare services, telecommunications and broadcasting services. For Type 1, these are infrastructure for continuous provision of essential services for the sectors. For Cat 2 infrastructure, they are ones that for the purpose of maintaining critical societal and economic activities, such as major sports or performance venues and science parks. There are also different kinds of threats, such as cybersecurity threats and physical threats. The bill imposes obligations on the CIOs to protect the critical computer systems. There are 3 categories: organizational, preventive, and incident reporting and response. Now, drawing on the views of society, I'd like to highlight a number of concerns. The first is about definition of critical infrastructure and their critical computer systems, as well as requirements relating to computer system security management unit, security audit, as well as the responsibility of the third-party service provider and whether personal data of clients or trade secrets would be involved. Now, in the interest of time, I will only focus on concerns expressed by the sector. As the title suggests, the bill regulates critical computer systems of critical infrastructure as well as the CIOs or operators of critical infrastructures. It is, however, technically difficult to put in place concrete definitions for these terms. There may be operations of different sizes, and they've told me that if they are designated critical infrastructure, there may not be sufficient resources to meet the bill's requirements. We have also, the bill has also made reference to the experience in the UK and Australia, and it clearly provides that only those designated as CIOs or CCSs would be subject to regulation. The crux is in the event of the system being disrupted or destroyed or suspended for a long time, whether it was substantially affect the essential services and the normal functioning of society. In Hong Kong, for essential services that are essential in maintaining societal and economic activities, they are mostly provided by large organizations. So, for safeguarding for preventing financial losses or salvaging clients and investors' confidence, these large organizations already put in place the relevant security management plans, and I believe that even after passage of the bill, it will not substantially increase the compliance costs for the large organizations. On the contrary, they serve as good reference in helping the authority assess whether sufficient resources are devoted to cybersecurity. On computer system security incidents and threats, broadly speaking, they refer to whether adverse impact would be caused to the critical computer systems or likely to be caused to the critical computer systems. In terms of computer system security, the definition in the bill is that it is free from disruption or being compromised. So that's the focus of this definition. Well, I have a question about this as to when an incident constitutes a cyber system security incident or threat. It is unclear, because regardless of the severity of the incident, as long as there is an adverse effect, it would be regarded as an incident. I am happy to learn that the government will provide some illustrative examples in the codes of practice for the sector to have a full grasp of what it means. I'm also told that among the 8 sectors, some sectors already have some statutory regulators, such as the MA and the Communications Authority. And they also have similar functions as the Commissioner. And the sector is concerned whether in the future they'll be subject to regulation by both the Commissioner and the designated authority, and that there will be substantial increase in compliance costs. I understand that the statutory sectoral regulating authorities will be designated as designated authority, and that together with the Commissioner, they will oversee the matter. And on this note, at the Bills Committee meetings, I asked whether the sector will be overseen by both the Commissioner and the designated authority, as well as whether what penalties will be meted out, and whether the sector will be subject to double penalties. According to the administration's reply, basically, the designated authority will oversee the Cat 1 and Cat 2 obligations to be fulfilled by the CIOs according to the law. And basically, failing to fulfill such obligations will attract a written direction from the designated authority, followed by a penalty, and there is no mechanism of double penalties. This can help the sector adjust to the regulatory model, and this can also help reduce compliance costs. Apart from setting out the obligations of CIO, I also suggest that the administration consider setting up a white list for third-party cybersecurity service providers. It's not just about firewalls, it's also about risk management of the whole supply chain. And I think the government should regulate third-party cybersecurity service providers as well, and see whether they meet baseline requirements in terms of professional know-how and their capabilities, so as to reduce the compliance costs on CIOs. Finally, I'd like to stress that no matter how stringent this regime is, it is also necessary that the management and staff, or even the public, have a greater awareness of cybersecurity incidents, and that is why the government should step up publicity and education, so that we have a greater awareness of protecting cyber critical infrastructure.
Mr. Martin Liao. Madam Deputy, technology moves in leaps and bounds. Businesses of all sizes and our critical infrastructures rely on the internet. So threats to our computer systems should not be brushed aside. When the computer systems of CIs come under attack, the community will be affected. Last year, there was a private hospital targeted by hackers. Some services were affected. Blood test reports had to be prepared manually instead. 2 years ago, Cyberport fell victim. The data of more than 13,000 data subjects were leaked, and then Macau government agency was also affected by overseas hackers, and government services there were disrupted. These examples point to the fact that cyber attacks can get in the way of socio-economic activities, and that can also undermine investors' confidence. The Protection of Critical Infrastructures Computer Systems Bill sets out different kinds of CIs, and those sectors include banking, energy, air, land, sea transport, healthcare services, telecoms, and broadcasting services. Usually, these systems contain personal and financial and also professional sensitive data. Legislating to protect these systems can protect the data from hackers. That shows the necessity of legislating for this. The mainland and Western countries already have laws in place to protect their critical infrastructures. The mainland has its own regulation on protecting the security of critical information infrastructure, and then the EU has its own cybersecurity directives. Hong Kong has already fallen behind. Cyber threats are constantly evolving. That's why we have to catch up by legislating. Last July, there was a 1-month consultation on this bill. 53 submissions were received, 52 were in favor of legislation and proposed suggestions. The Bills Committee also received many submissions in favor of the legislation, so it's only right for the government to legislate soon to respond to the community's calls. The chief executive will be empowered to appoint a commissioner for computer system security. The commissioner can investigate, make inquiries, enter premises, take documents, and also monitor systems. There are concerns that the commissioner may request sensitive and confidential data and access the computer systems of businesses. This bill will only cover critical computer systems, meaning sensitive personal data and trade secrets are out of scope. It's only when a CI operator is unable or unwilling to cooperate, and only then the commissioner can apply to a magistrate for a warrant. So there's no cause for worry for people and businesses. During the BC's meetings, we were alerted to the fact that small and medium businesses were worried about resources. They worried about the lack of funds to comply with the bill. So some support should be given. On defining critical infrastructures, critical computer systems, risk assessment requirements. On these matters, an affected organization can actually appeal to an appeal board. The chief executive can appoint at least 15 members to the appeal panel. The chairperson will have to have a judicial training, and there will be lay members and professional members on the panel, and that will bring diversity to the future appeal panel. Cybersecurity of critical infrastructures may involve complex issues. And that means we will need more input from information security professionals, so the government should consider adjusting the share of IT professionals on that panel. CI operators will also have to appoint someone with enough professional expertise in cybersecurity. But this is a vague concept. Enough expertise in information security. An operator of CIs may not have the knowledge to tell who can't. So in the future code of conduct, more guidance will be needed. Technology constantly changes, so the government should be constantly reviewing those requirements. On the penalties, the bill proposes that for non-compliance with the future ordinance and the code of conduct, say a request for information, the maximum fine will be $500,000 to $5 million. And then after a trial, when conviction ensues, there can be a daily fine of $50,000 to $100,000 per day. Let's look at Singapore. They also have their own cybersecurity law. It's $100,000 and 2 years in jail. In the EU, there's Cybersecurity and Information Security Directive 2. The maximum fine is 10 million euros. So what we are proposing is already lenient. The penalties will only target organizations. We're not trying to punish the operators. We're simply trying to help the CI operators to run their systems more effectively. So I welcome the proposals about penalties under the bill. Cybersecurity is a key part of national security. For our national security in Hong Kong, this bill is crucial. Keeping the computer systems of critical infrastructure safe will strengthen Hong Kong's resilience, and that will enhance our international image. And then Hong Kong can become an international INT center. I support the second reading of the bill. I so submit. Mr. Ronick Chan. Madam Deputy, as we go digital and we move faster on this, and critical infrastructures are becoming integrated with each other, and then we're also getting more cyber incidents, data leakages. Even the hospital fell victim to cyber attacks. Now, the Hong Kong Computer Emergency Response Center also handled more than 12,000 cyber incidents last year. So we can see the threat from cyber attacks. There were losses. Now, for energy, banking, healthcare services, air, sea, land transport, the systems in those sectors may be targeted, and when those systems are compromised, the services are affected, the community as a whole will suffer. So keeping those critical systems safe would be all the more important. In 2021, the mainland enacted its own regulation on protecting the security of critical information infrastructure to keep the critical systems safe and maintain cybersecurity. Mr. Martin now cited a number of countries, Australia, the EU, and Singapore have also enacted their own laws on this front. We are enacting this bill to protect our own computer systems of critical infrastructures. We're trying to step up cybersecurity. We're protecting our systems from attacks. I support this. I was a member of the Bills Committee. At the clause-by-clause scrutiny, I raised many points about this bill, and that included the drafting, implementation, and also potential impact. I'm pleased to see that the government took on board most suggestions and will propose amendments. I want to thank the Security Bureau and the Department of Justice for their hard work during the scrutiny. Hong Kong is an international financial center. Banks and financial institutions matter not just for settlement or deposit, but also for the cross-boundary flow of money and also data exchange. That's important for our economy and the flow of capital. Our banks strictly follow the banking ordinance and also the code of practice for banks. The banking industry generally supports legislation as a way to strengthen protection for banks and financial institutions, but let's also guard against increasing the compliance costs for the sector. As someone from this sector, I want to share some thoughts. Now, on reporting any cybersecurity incidents, when an FI becomes aware of an incident, they have to let the HKMA know right away. This bill also requires an CI operator to let the commissioner know. During the scrutiny, the government said that for one incident, both the commissioner and the industry authority will have to be informed. And whatever incident happens, two parties need to be informed, so more work will be involved in reporting an incident. Now, the government told us the reason for informing each party is different. For the HKMA, you let the HKMA know. That's because of service continuity. As for letting the commissioner know, it's about intervening after an incident and prevent and doing damage control. Now, because since we're informing different parties for different reasons, two parties need to be informed, and the industry expresses understanding. The industry simply hopes that the notification requirements will be broadly the same as the old one about informing the HKMA. So if we can do that, we can minimize the disruption. Now, clause 25 says that there will have to be security assessments or security audits. In fact, such audits have been around in the industry, and such audits have been entrusted to professional bodies. As for the qualifications of such audit providers, the government told us you can hire an external auditor, or you can get an independent audit division within that organization. You just need firewalls to ensure the independence of the auditor, and that will be fine. There will be codes of conduct to set out in greater detail what's needed. The industry would like to see that the future security audits can be in line with what's already required by the HKMA so as to minimize the compliance costs. Clause 26 says that with reasonable written notice, a CI operator can take part in a cybersecurity drill required by the commissioner. In fact, the HKMA has required regular drills for banks. That's to ensure that when something unforeseen happens, banks can continue to offer services, and that can minimize the impact on customers and the public. Such security drills are something that banks are used to. So, when drills are required for critical infrastructures, please talk to the banking industry early on and give them detailed guidelines so that the bank will know the scope of the drills and they can prepare accordingly, and that can minimize impact on their daily operations, and that will also ensure the drills will meet its goals. During the scrutiny, many members offered suggestions such as setting out clearly the roles and responsibilities and more details for different requirements. The government told us there would be codes of practice and there would be detailed requirements such as the size of the cybersecurity unit and their qualifications required for the people involved, what counted as an incident, and when an operator will have to let the operator know, and with examples. We will need details so that everyone knows what to expect. The codes of practice will cover a wide range of matters, complex matters, so in drafting and revising the codes, please fully consult the industry. Please take on board industry feedback so that the codes will be able to meet the needs of the industry, and then the codes can be implemented, and then the codes will be adopted. Madam Deputy, I support the bill and all amendments as so submit.
Mr. Kenneth Lau. Deputy President, I speak in support of the passage of the Protection of Critical Infrastructures Computer Systems Bill. Critical infrastructures are key to the lifeblood of the community in Hong Kong. Otherwise, impact would be caused to the supply of utilities in society, and there would be substantial panic as well as panic buying in Hong Kong. This will paralyze Hong Kong and threaten the security of the country. All over the world, there is an increasing level of cyber attacks. There's a report saying that in 2024, ransomware all around the world reached 5,400 or so cases, up by 11% from 2023. Hong Kong is facing serious risks of cyber attacks. Public organizations are facing attacks by hackers. There are also computer system security loopholes, leading to personal data leakage. In 2024, Hong Kong Computer Emergency Response Team Coordination Center handled 12,536 cases, half of which were phishing cases, up by 108 cases comparing with 2023. Banking, energy, transport, these are the main targets. If they are attacked, then the consequence will be dire. Therefore, we must enhance the level of protection for the security of computer systems, land transport, air transport, energy, maritime transport, healthcare services, telecommunications and broadcasting services, banking and financial services. These are the 8 sectors that we must focus on. Major sports and performance venues, research and development parks, these should also be protected. CI operators need to take measures to protect their computer systems. They should also enhance their resilience against cyber attacks. In the case of computer system attacks, CI operators need to report to the regulating authorities within 12 hours. Within 48 hours, that is a threshold for other computer system security incidents. In China, in EU, there are also pieces of legislation in relation to cybersecurity. In Hong Kong, the administration has taken into account the local situation in formulating the bill. We have received 53 representations, most of which are supportive of the bill. Just one submission was from a human rights organization in the UK. It is against the legislation and it attempted to smear the bill. Well, the administration has already explained that most of the organizations being regulated are large organizations. SMEs and the public are not the subject of the regulation of the bill. The bill seeks to protect the security of computer systems of CI. It has nothing whatsoever to do with the personal data. It has nothing to do with online activities of individuals in Hong Kong either. However, there are also concerns over the power of the Commissioner's office, which might affect the normal operation of the computer systems. The administration has already emphasized that the powers of the regulating authorities are limited to investigation. Warrants have to be obtained from the courts in order to execute the power that will allay the concerns of the industry. The Bills Committee held 4 meetings lasting for around 17 hours during the Bills Committee meetings. I am glad to see that the administration has taken on board our views, and there will also be amendments in Clause 19. It's about the obligation to maintain office in Hong Kong, and there needs to be a correspondence address. The administration will propose amendment in relation to Clause 19. In other words, the operator needs to have a physical office in Hong Kong. That is to enable the regulating authorities to conduct follow-up with the operator, and that will also enhance the efficiency of regulation. International landscape is changing. Some countries impose sanctions on Hong Kong, so to speak. We need to guard against any hidden viruses from the systems we procure from other places. Owners and operators of CIs should give priority to the software and computer systems from mainland China. In engaging computer system security personnel, in addition to professional know-how in the contracts, it needs to be stipulated that any illegal act or act against the interest of the country should be forbidden. Protection of CI computer systems is key to safeguarding national security. Since 2023, the Security Bureau started carrying out consultation sessions with different stakeholders. There is overwhelming response from the community. The administration will propose amendments having regard to the views collected. So this is a good time to implement the ordinance and introduce the bill to the Council. I so submit. I speak in support of the bill. Thank you, Deputy President. Professor Chow Man Kong. Thank you, Deputy President. I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. In 2022 policy address, the Chief Executive said that we need to tie in with the legislative intent of the National Security Law. 4 initiatives were mentioned. One initiative was legislating for Article 23, which was completed last year. And the other task is the second reading debate of the bill in question. I'm glad to see that the administration is taking forward these initiatives in an orderly manner. We can safeguard national security by building a protection net. More importantly, we will also guard against external risks. There are risks threatening the country from different levels, say economic risks and so on. This has an impact on personal data as well as livelihood of Hong Kong people. Earlier this year, Hong Kong CERT published figures. In 2024, the center handled over 12,000 cases in relation to cybersecurity. Follow-ups were conducted. Reminders were also sent to different stakeholders. There are risks in relation to these cyber attacks. In August 2023, Cyberport experienced a cyber attack incident. A lot of personal data were sold online. This shows the security loopholes of Cyberport. This also points to the problem with the computer system audit. The administration has drawn reference from a lot of different jurisdictions, including Macau, Australia, the US, and the UK. A total of 8 sectors were covered. They delivered essential services in Hong Kong. There are also other infrastructures for maintaining important societal and economic activities. They are subject to the regulation of the bill. Mainly operators are targeted. Comparing with other jurisdictions, the regulating scope is quite restrained. There was widespread consultation in the community, and there was also sufficient discussion at Bills committee meetings. I asked questions during the Bills committee meeting, so I'm going to put forward 3 grounds for supporting the bill and 2 follow-ups. First of all, on my 3 supportive views, the bill is protective instead of penalizing different operators. Operators need to have a good understanding of legal concepts. This is very important. Under the bill, operators need to maintain a close liaison with the Commissioner's office. They need to have a computer system security management plan, and there will also be a notification system in order to enhance their resilience against cybersecurity risks. The Secretary for Security replied to me that this bill only lists the infrastructures for delivering essential services in Hong Kong, but the list will not be published to the public. The infrastructures will be informed in order for them to conduct their annual audits. The reporting time frame was amended. Operators need to restore the system in order to contain the spread of the impact. The reporting of serious computer system security incidents was relaxed from 12 hours to 48 hours. For other computer system security incidents, it was relaxed from 24 hours to 48 hours. The bill only concerns the financial penalty, and this has sufficient deterrent enough. The administration has drawn reference from the UK and EU. Only fines are involved, from $500,000 to $5 million, and there is also an additional daily fines for persistent non-compliance. Therefore, I am not worried that the bill will affect the business environment in Hong Kong. Instead, this will be beneficial to the operation of the banking sector as well as the healthcare services sector. This will ensure the smooth operation of society. I'd like to put forward some suggestions. The coverage should be extended to other sectors, say the higher education sector. In 2023, there was a cyber attack against a university in mainland China, exposing the university to different cybersecurity risks. Drawing reference from the US and Australia, we can see that they have incorporated the education sector into the regulation scope. There is the promotion of commercialization of R&D outcomes in local universities. We need to protect their R&D outcomes, so the administration may consider including the education sector to the Schedule 1 to the bill. They should be covered in the regulation scope as well. We also need to enhance the training of cybersecurity personnel. Upon the passage of the bill, CI operators need to engage the relevant personnel to enhance the level of protection. Information shows that INT employees only account for 1.2% of the entire industry. They are in relation to computer system security personnel. So I suggest that universities should provide programs on internet or cybersecurity engineers. This is a highly sought after discipline in Hong Kong. And this is also in response to the surge in demand for such talents in Hong Kong upon the passage of the bill. Apart from hardware, we will also be prepared on the software front. I support the second reading and third reading of the bill. Thank you.
Ms. Elizabeth Quat. I declare that I'm an advisor to China Mobile. Thank you, Madam Deputy. I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. I'm going to give my view on a number of areas. Now, in the latest international landscape and escalating cybersecurity problems, cybersecurity is a major challenge to countries around the world. Is also a core element for safeguarding national security. According to a safety index in Hong Kong, the cybersecurity resilience ranked the 5th in 2019, and it has since dropped. Now, according to the police, the economic loss due to cybersecurity crimes increased by 217% comparing to 2020 to a tune of $5.8 billion. Government departments and private hospitals were subject to a ransomware attack, and the acute and emergency services were suspended for close to 72 hours. That shows the vulnerability of the critical infrastructures in Hong Kong. Together with geopolitical risk, there is urgent need to enact legislation. Now, around the world, we also see similar incidents. In the U.S., the water supply system was subject to hacking activities. In Venezuela, there was national power outage due to cyber attack on the supply system in Israel. All these shows the importance of protecting critical infrastructures. Hong Kong is an international financial center, and we are working at full steam in different directions of development, such as smart city, AI, and low-altitude economy, digital economy, etc. These are strategic emerging industries, and we need to take preemptive action to safeguard our cybersecurity. Now, there are two categories of critical infrastructures. The first one covers 8 sectors, such as financial services, healthcare, transport, etc. These are infrastructures for continuous provision of essential services in Hong Kong. The second category refers to infrastructure for maintaining critical societal and economic activities, such as major sports and performance venues. Now, the categorization of infrastructures could help the administration ensure the security of core infrastructures and maintain normal functioning and normal livelihood of society and the people. I think we need to think further. After consulting the experts in the field, especially cybersecurity specialists, I have the following suggestions in terms of implementation of the bill. And after listening to my suggestions, the government has agreed to consider my suggestions very carefully. On COPs, I propose including the CMU and EMPF into the regulatory framework. The EMPF involves 4.6 million employees in Hong Kong and their retirement benefits. So the MPFA should also be designated as a regulating authority, and that should be it should also help set the requirements. Now, the other point is about emergency response plan. We should abide by the ISO 22301, which is about continuous or sustainable management. We should also make reference to cybersecurity framework in drawing up the contingency plan. On implementation, my suggestions are as follows. The first one is about the training of talents. We should take a systemic approach. That means for key post holders, they should undergo certain hours of accredited training per year. We should also set up a framework and demand regular drills. Very often in the past, after cybersecurity incidents, there might be some other problems because staff did not receive adequate training, the organizations did not have sufficient guidelines. The staff thought that by rebooting the system, it could solve the problem. And this actually caused the deletion of some ROM or transient data. But the transient data are exactly very important in preserving evidence. The other point is this. After passing the bill, third-party service providers may be involved in the protection of critical infrastructures and may be cross-boundary flow of data. That is why we need to set up a system for the backup of core data. We also need to make reference to GDPR Rule 28 in terms of the obligations of third-party service providers. There should also be security assessment guidelines on the outflow of data. Now, smart city is of utmost importance, and cybersecurity is the infrastructure supporting the development. I hope that in the COPs, more tactical or operational arrangements can be included to further improve cybersecurity in Hong Kong. Mr. Chan Kin-po, with technological advancements and geopolitical tensions, we are facing more and more challenges. There is an urgent need for Hong Kong to enact legislation to protect critical infrastructures and the computer systems so as to bolster our status as an IFC and to provide a favorable business environment. The purpose of the bill is to enact a legislative framework targeting the security of critical computer systems, and some sectors are covered, such as financial services, banking, land, air, maritime transport, healthcare services, telecommunication services, energy, and I&T, so that the operators of these critical infrastructures can be shielded from unnecessary attacks and incidents of data leak or trade secrets leakage. According to the administration and from the administration's paper, we understand that the bill does not target personal data or trade secrets. There will be COPs to set out the nitty-gritty. For example, Part 4 of the bill imposes 3 categories of obligations on CIOs. The first one is organizational. There should be proper management and a framework. A commissioner will also be appointed to oversee the CIs. The second category refers to preventive obligations. The third categories refer to incident reporting and response, and these obligations include conducting security assessment and coming up with a management plan, etc. The third category refers to incident reporting and response. The operators must draw up emergency response plans to make sure that system loopholes are plugged and that they could respond swiftly to incidents. The Commissioner will work fully with the operators. In the event of incidents, interdepartmental coordination is required to ensure sustainable operation of the critical infrastructures. The administration took patience in answering our questions and addressing our comments. They've also incorporated our suggestions in the CSAs, so I'm going to support this bill.
Mr. Duncan Chiu. Madam Deputy, I'm an advisor with China Mobile. I'm also with the hospital authority, and these bodies may become critical infrastructure operators. Cyber threats are everywhere. You may end up with monetary losses, data leakages. But worse, national security may come under threat. Many countries have enacted their laws to protect their critical infrastructures. The recent years have seen a spate of attacks, cyber incidents in Hong Kong, hackers attacks, cyber scams. Cyber risks are on the high side in Hong Kong. The I&T sector would like to see enhancements to laws to protect cyber and data security. What matters above all is to protect national security. So I support the protection of critical infrastructures computer systems bill. I also support the government amendments. This bill imposes statutory obligations on operators of critical infrastructures. I did not get to join the Bills Committee. I did not take part in the discussions. But when the government briefed the panel on security on this proposal, I put my questions and I hope the government would consider these points. First, defining critical infrastructures, defining the scope, whether e-payment platforms and smaller data centers should be covered, and whether there would be extended support for businesses, and whether we can have a white list of security audit providers for smaller players. And I hope the government would carefully consider how the platforms operate so that businesses don't inadvertently breach the law. Now, on the scope, the bill sets out that energy, INT, banking, air, land, maritime transport, healthcare, and telecoms, a total of 8 sectors, are critical sectors, meaning they are type 1 critical infrastructures. But which businesses will be covered? Many organizations are left guessing whether they will count as an operator of CIs. When will they be informed? Will they have enough time to prepare? The industry is wondering. Clauses 11 and 12 say there will be factors such as the types of services provided by that body, and if compromised, if there's a data leakage, what impact will there be? And those factors will be considered by the government in designating a certain operator as a CI operator. And when a CI operator is designated, reliance on the system and the core functions of that system will also be considered, and also whether sensitive data are involved, and the control exercised by that operator on the critical infrastructure. Once these factors are considered, the operator will be informed in writing. At the Bills Committee, members have already raised such concerns, meaning the regulating authorities should offer clear guidelines about how an operator is designated as a CI operator so that those operators can prepare early on. The administration said after the bill's passage, the commissioner and the designated authorities would issue guidelines where needed so that those operators get a clearer picture about how the designation will work. The administration also said they will look at the organizations and their readiness in designating CI operators in phases. So operators likely to be designated as CI operators will have ample time. The government said they will issue guidelines when appropriate. We have no timetable about when the guidance will come out. So the industry is still worried. There are concerns yet to be allayed. That means for the government, it should issue clearer guidance sooner. Don't just issue guidelines when appropriate. That can put minds at ease and organizations can prepare in good time and they can meet the requirement to complete the procedures based on the deadlines. Part 4, obligations on CI operators. There are 3 kinds of obligations. Type 2, preventive steps, protecting computer systems from threats. Type 3, incident reporting and response. Type 2 and Type 3 responsibilities have to do with incidents. Incidents are defined under Section 2, subsection 1. Now, incidents have to meet a few requirements. 1, unauthorized access to a computer system. or any other act done without lawful authority on or through the critical computer system or another computer system, or anything that causes an actual adverse effect on the computer system. Say, a CI operator's website is malfunctioning. They don't know if that's a hacker's attack. Is that an incident? Does it meet the requirements under the bill? Does that company have to alert the commissioner? Examples illustrating reportable incidents may help. Now, when a website is down, the impact can come in varying degrees. Say a website of the power company is down. That may create a different impact from, say, when the website of the airport authority goes down. So can we have guidance on what is a reportable incident? So I hope the future codes of practice can clarify these points. Now, on Type 1 obligations, it's about the organization. It's about the computer systems of the critical infrastructures. The operator has to appoint an officer to manage the computer security unit. The BC members and legal advisor asked the administration whether that person had to have qualifications and experience and how large that security unit had to be. The government said it would not spell out the qualifications. There would be no hard and fast requirements. Instead, in the future codes of practice, there will be guidelines on the computer system security management unit. It says a computer, there would be guidance on the credentials needed, say international recognized credentials. But how do we ensure those management staff have the knowledge on cybersecurity? After all, technology is constantly evolving. Can the future codes of practice keep up? So we have to keep updating those requirements. The codes of practice should also take into account mainland qualifications. Madam Deputy, there are now dedicated staff at businesses for cybersecurity. But cybersecurity measures leave much to be desired. Some businesses say they don't hire a third-party service provider, they don't update their systems on time. Now the fines are set to $5 million, up to $5 million. What matters even more than the fine is to conduct a community-wide publicity campaign. Let's raise awareness, and that's how we can better protect our data and cyber systems. I so submit, Madam Deputy, I support the Protection of Critical Infrastructures Computer Systems Bill and the amendment. Mr. Rincon. Madam Deputy, I support the Protection of Critical Infrastructures Computer Systems Bill. Now, the World Economic Forum issued a report in January 2025, the Global Cybersecurity Outlook 2025. 72% of the organizations surveyed said they expected cybersecurity risks to go up. Generative artificial intelligence may also strengthen cybercriminals. Cyber incidents have happened one after another that affected businesses and also seriously threatened the operation of critical infrastructures. There was a conference on cybersecurity in 2024. Malware and ransomware will become more serious threats. Regulation is the way to go. And that can also strengthen trust between users. This morning, there was a media report. Cybercriminals now adopt sophisticated tactics. They target the energy facilities, hospitals, and government agencies. To meet this growing threat, many places have already been treating the computer systems of their critical infrastructures as matters of national defense. So there is a pressing need to protect the computer systems of critical infrastructures. For this bill, operators of CIs have to meet certain obligations. Prevention, for example, security audits, and also reporting incidents. Let's look at other places. Our requirements are comparable to those of other places. Our requirements are not unduly onerous. In Switzerland, for example, an operator has to give notice within 24 hours. For our bill, we require giving notice within 48 hours unless the interference has to do with the core functions of the critical infrastructures. With this bill's passage, I hope the government can remain in touch with stakeholders. Let's prepare the codes of practice swiftly. Let's also give owners of critical infrastructures enough time to prepare for the requirements so that we're not creating undue onerous compliance costs. For this future ordinance to work, we will need the commissioner and their team, as well as all the operators to work together. What's also needed is community-wide support. Cybersecurity experts and specialists are vital for our CIs, so the government should ensure we have enough such specialists in the ecosystem so that they can support the implementation of the future ordinance. Cybersecurity risks are constantly evolving, and this bill will only provide a framework. To keep our cyber systems safe, we need different sectors to work together, and we have to build up our capacity so that we can build resilience in our CIs. The government should constantly review our ordinance, remain in touch with stakeholders so that we can find a solution that works for everyone. We keep our systems safe, and we create a more robust and reliable business environment for businesses so submit.
Dr. Johnny Ng. Digital technology is developing by leaps and bounds. It is closely related to the everyday life of Hong Kong people. There are cybersecurity risks. It is very important to enhance the security of computer systems. The purpose is to protect energy, information technology, banking and financial services, land, air transport, maritime transport, healthcare services, and telecommunications and broadcasting services. We need to protect Hong Kong people. Then we can also protect our status as an international financial center. There are more and more cybersecurity incidents. There are attacks against public organizations and government departments. According to figures from the Digital Policy Office, Hong Kong CERT handled over 10,000 cases in 2024, up by 40% from last year. The situation is alarming. At present, there is no statutory requirement in relation to the protection of critical infrastructures. In other advanced economies, there is existing legislation in this regard. In October, the Chief Executive announced in a policy address that there would be legislation regarding the protection of critical infrastructures. The Security Bureau drew up this bill accordingly. Stakeholders were consulted. The bill was tabled to the Council for scrutiny. We need to applaud the administration's efforts in this regard. The security of computer systems is vital. The purpose of legislation is to enhance the security of computer systems and minimize the risk of the compromise caused to computer systems. There are two main types of critical infrastructures. One, infrastructures for delivering essential services in Hong Kong, covering energy, IT, banking and financial services, land transport, air transport, maritime transport, healthcare services, telecommunications and broadcasting services. The second type is other infrastructures for maintaining important societal and economic activities, say major sports and performance venues, research and development parks, and so on. An organization-based approach is used. There is a requirement for organizations to report the incidents that have happened. The aim is to protect Hong Kong people. Therefore, we can create a more favorable business environment. In formulating the legislative framework, different jurisdictions, the administration has drawn reference from different jurisdictions. The administration has already struck an appropriate balance. The framework also provides only designated CI operators and their critical computer systems will be subject to regulation. Most of these organizations are large organizations. SMEs and the general public are not subject to the regulation of the bill. This is an appropriate move. The bill only targets organizations and doesn't target individuals. Only financial penalties are involved under the bill. Operators shoulder the responsibility for protecting the computer system security. The penalty level ranges between $500,000 and $5 million. The administration should take stock of the situation and review whether these fines are reasonable. Compensation should also be made to Hong Kong people who are affected by any cybersecurity incidents. The protection of critical infrastructures and computer systems is key. It is necessary to do so. I support the passage of the bill. Thank you. Mr. Sunny Tan. Thank you, Deputy President. I am the chairperson of the Hong Kong Productivity Council. Data security, financial security, all these are important in safeguarding national security. Hong Kong is an international financial, trading, and INT center. The protection of CI computer systems is very important to safeguarding national security and protecting our country. It is an important step in ensuring the robust development of Hong Kong as well as our prosperity. We rely on digitalization in Hong Kong. Hong Kong CERT has been protecting Hong Kong. It handled over 10,000 cases last year in Hong Kong, over half of which were phishing cases, which was a record high. The bill protects critical infrastructures operators and require operators to protect their critical computer system security. This is an important step and it is necessary. I have a few concerns. For Central Clearing and Settlement System, FPS, that is Faster Payment System, Central Money Markets Unit, as well as IM Smart Plus, all these are very important tools in the business sector in Hong Kong. I believe the Commissioner's Office will identify these tools and ensure the financial security in Hong Kong. The administration said that this bill isn't applicable to the government. The ground they put forward is that within the government, they already have a government security regulations as well as the government information technology security policy and guidelines. I hope the relevant department and quasi-official organizations will keep reviewing the policy as well as the guidelines in order to protect data as well as personal information. Some SMEs might be designated operators under the bill. The compliance costs will rise. They are concerned about this. I hope the administration will consult stakeholders and provide necessary support to SMEs. They can also provide support through INT and help them with operation. Public organizations should be enlisted in order to protect computer systems of CI. I support the passage of the bill. Thank you.
Ms. Eunice Yong. Madam Deputy, I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. The computer systems of critical infrastructures are the linchpin of the stability of society and people's livelihood. Around the world, critical infrastructures are often the subject of cyber attacks. The threats are escalating. In recent years, we saw a number of incidents, such as power outage incidents because the power supply systems were under attack. There were also incidents relating to industrial systems being stalled because of attacks, as well as hacking activities halting financial transactions. All these have brought unimaginable impact on normal functioning of society and people's livelihood. Now, Hong Kong is an international financial and trade and shipping center. We have a lot of important critical infrastructures. And the computer systems form the linchpin of financial transactions. Our banking and financial services sector must be protected to ensure smooth flow of funds and smooth operations, and they also keep our deposits safe. So if there is anything wrong with the computer systems of the sectors, the whole society will become chaotic. Now, this bill covers 8 sectors, including energy, INT, transport, financial services, healthcare, public utilities such as water supply, waste, sewage treatment, etc. I hope that protection can be provided to these computer systems to safeguard our well-being. Now, in terms of definitions of critical infrastructures and operators of critical infrastructures, there are clear definitions. Critical infrastructure covers those in the 8 sectors, such as energy, INT, banking, financial services, air transport, land transport, maritime transport, healthcare, as well as telecommunications and broadcasting. These sectors also process abundant data, and the compromise of the data of these sectors may affect and hinder the critical societal and economic activities in Hong Kong. That is why we need to impose obligations on the CIOs. CIOs must set up dedicated management unit so as to ensure security of the computer systems. The dedicated management unit can devote resources to deal with the overall surveillance of the computer security or security of computer systems and to respond to incidents. In terms of design, safety, and operation of critical computer systems, should there be material changes, deletion, alteration of the systems, the operators will be required to submit a report within a month, and that a safety plan should be submitted within 3 months. The plan should be put into action, and that means regular security assessment and audits should be conducted. Reports should be made. These are preventive obligations. By imposing these obligations, we can set up a good line of defense for the protection of computer systems of critical infrastructures. In the event of incidents, the bill sets out obligations for the operators to make reports and to take action. At the Commissioner's request, the CIOs should take part in the drills at a certain time frame, depending on the severity. They are also required to submit written reports. This category of obligations can help minimize adverse impacts and loss in the event of incidents. Now, in terms of education, it is equally important. With technological advancements, there are more and more challenges in the realm of cybersecurity, and there are new hacking and emerging hacking patterns. From Trojan horses, we are now moving towards the use of AI and data analytics that can help hackers launch more precise attacks. For example, they can make use of big data analytics or algorithms to analyze the target system so as to find the loopholes. That is why the relevant sectors should be more vigilant against the latest trends. That means we should step up training for staff, especially on the security of computer systems. On a regular basis, training should be provided, seminars should be held. Experts and scholars should also be invited to share the latest cybersecurity incidents and technologies for staff to learn, to upgrade their skills. Schools, vocational education institutions in Hong Kong should also be enhanced. The curriculum should be revamped to include the latest development of cybersecurity so as to groom more visionary talents with professional skills, so that in terms of protecting our critical computer systems, we can stay in the lead. Now, I understand that we have consulted different trade associations in the financial services sector, the logistics sector, etc. And they all indicate support for the bill. In this digital era, it is only the first step for Hong Kong to protect critical infrastructures in the computer systems. We need to do more to enhance our competitiveness. At the same time, with the passing of the bill, we can show to the world our determination in safeguarding economic development and protection of infrastructure. Mr. Tang Fei, Madam Deputy, I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. With the passage of the bill, there will be more protection of infrastructures and their computer systems in Hong Kong. We'll be able to enhance our competitiveness in the global community, and it is very significant. In this new digital era and the AI era, critical infrastructures are critical to our socio-economic development, as well as the normal functioning of, say, the energy sector, transport system, financial services, etc. In recent years, there have been very frequent cyber attack incidents around the world targeting some critical systems and causing a major threat to the economy around the world. I'm not going to repeat these incidents and the statistics. Hong Kong is an international financial center and a regional hub. Inevitably, we face the similar cybersecurity threats. Madam Deputy, now if the bill is passed, we need to consider this. Cybersecurity is a very important element in the holistic view of the national security of our country, and that this is something really close to the heart of every country. National security is also closely related to the day-to-day living of people. So this bill proposes a comprehensive legal framework for the government and the relevant organizations to effectively guard against cybersecurity threats and incidents. I really appreciate one point in this bill, and that is the government has made reference to the legislation in other jurisdictions. They've also made reference to legislation in our country before drawing up a framework that is suited to Hong Kong's situation. That means we're able to catch up with the rest of the world in terms of putting in place a legal framework on cyber security. And this bill basically regulates major organizations. For SMEs and ordinary citizens and their staff members, they are basically not affected. They won't be held criminally liable. For operators of critical infrastructures, the legal framework provides obligations. They are on the relaxed side, and I would say that these are effective at the same time. The bill doesn't go after personal data or trade secrets. According to other fellow members, there should be sufficient guidelines on and sufficient time for CI operators to get ready. Does it mean that we must rely on the codes of practice or for the commissioner to designate the CIOs and provide guidance, or are we able to make use of subsidiary legislation? That's a suggestion that the administration should carefully consider. Now, education is not one of the 8 sectors covered, not even the higher education sector. Hong Kong is positioned to be the international post-education hub, so I would say that this is relevant. With digitization of education, there are also critical infrastructures in our sector. Their security is at stake. For many post-secondary and research institutions, they also rely on a secure and stable cyberspace. Our target is to attract top-notch scholars and students and education institutions to set up presence in Hong Kong, and as such, we should pay attention to this demand. I think that by including the education sector in this bill, we'll be able to attract more quality students and scholars and education tech firms to come to Hong Kong. Because very often the scholars are concerned about their R&D outcomes and whether their work will be plagiarized. It's not just about protecting the intellectual property rights, it's also about national security. Because the achievement of a research scholar is very much about presenting the outcome stored in this computer system or some sort of hardware connected to the internet. So for serious cyber attack, it may be about trying to steal this outcome at the national level. So I think that it is also related to national security. We need to enhance the awareness. In these education institutions, they possess data relating to, say, the personal data of students, professors. Now, this piece of legislation does not tackle deception. Still, if we're able to better safeguard the personal data of students and professors, it would help tackle deception cases. In fact, in the past decade or so, not only were university students subject to hackers' attacks, many secondary or primary school servers were blocked because of DDoS attacks, and these systems became paralyzed. So if the bill is passed, the operators providing this hardware and software platforms for schools may be designated as operators of CIs, and in a way, the data security can be achieved in schools. Now, with the passage of the bill, there would be a stimulus for the economy. We have some tech firms and education tech firms setting a presence in Hong Kong, and they can provide technical solutions that can help promote the development of digital economy. For audit service providers, if the government is able to provide a white list, there will be business opportunities for the relevant organizations to bid for the jobs in a way that can drive businesses. Now, this bill is a demonstration of how Hong Kong is integrated into our country. In the 14th five-year plan, there's a suggestion that we should promote digital economy and enhance cybersecurity protection, and Hong Kong should be in the lead in order to dovetail with national strategy and to set ourselves as a demonstration zone in the Greater Bay Area. So as to catch up with the latest trend, I support the bill.
I'm cueing you.
Mr. Dennis Leung. President, I speak on behalf of the FTU. We support this bill, the Protection of Critical Infrastructures Computer Systems Bill. The FTU stands up for workers' rights. We believe development is for democracy, security comes first. On this debate about this bill, we have to highlight the importance of this bill in keeping our critical systems safe. We also have to be mindful of the implications in the enforcement of the bill. Our daily transactions on our financial trading platforms are at $12.6 trillion. Our MTR system carries 45% of our commuters. So we have so many systems supporting our city's vital operations. When an energy system is attacked, there may be massive power outages. When our stock market system crashes, there will be huge losses. So cybersecurity then becomes a public security issue. Now, we are an international financial center. Last year, APT, Advanced Threat, rose by 37%. 62% of their attacks had to do with hackers groups with geopolitical reasons or motivations. That means we need a cybersecurity resilient system commensurate with our status, and we have to guard against risks. The FTU supports the principles of this bill. We also need a three-dimensional system: security, defense, and economy. We have to strike a balance between regulation and compliance costs. We also have to strike a balance. Let's make allowances in the early days of the bill. And now here are the FTU's ideas. 1. We need sector-specific regulatory regimes for finance and energy, which are strategic sectors. We need thorough regulation, real-time monitoring, information sharing, regular drills. Now, for retail, manufacturing, F&B, food and beverage, we need longer transition periods. During the transition, let's provide technical support instead of imposing penalties. After the bill's passage, let's keep an eye on how things go. Let's look at the losses. We should have a tiered system to enhance protection. A survey shows 83% of Hong Kong's SMEs lack a dedicated cybersecurity officer. So that means we need a fund at least $500 million for SMEs to identify their loopholes. The Employees Retraining Board and the VTC should offer courses on cybersecurity certification. We should train up 1,000 such professionals in 2 years. We need more advanced certification courses down the road. We should not stop at incident reporting. We need an emergency response system across departments. When a cybersecurity incident happens, we need to trigger the response mechanisms across departments to ensure continuity of public services. Let's look at TAPCO. They have this four-window mechanism. We need an emergency response manual for the entire city. We need regular drills and meetings to look at new strategies, new response tactics. Now, this bill will cover operators, but there is no mention of advisory panels, no industry reps on the advisory panels, and there's no way for us to gauge industry views. So I suggest that the government set up advisory panels with SMEs making up at least 30% of the panel so that we keep an eye on the impact of the bill on the industry. Let's look at Germany's Industry 4.0 strategy. Let's learn from their experience. Let's create a tripartite system. Unions, trade unions, firms, and workers. We want to keep our system safe for people's well-being, but let's also bear in mind of the flip side. Geopolitics, US-China trade war. We have to bear in mind the security dimension of software and hardware, and we have to bear in mind compatibility. Industry may run into difficulties because of rising costs, so the government should offer support. The safest way is to store data locally. So for cross-boundary logistics and e-commerce, let's create a whitelist for those businesses. Let's support those operators of those facilities. Now, on labor rights protection, this bill may lead to structural shift in industry. Say, service staff may lose their jobs. So the FTU suggests that the government should launch retraining program. Let's offer subsidies. Let's offer reskilling courses, and make reskilling courses a mandatory part of the ERB or VTC's courses. 2016, WannaCry. 2023, we had deep fake. That shows threats come in all forms and sizes. So let's review the situation, and the government should submit technical reports to LegCo. Let's also create sandboxes so that businesses can test out new protection solutions in a controlled environment. So that will leave room for tech innovation while keeping things safe. The FTU believes a good law should be like a surgical scalpel instead of an indiscriminate sledgehammer. So we suggest a three-tier system. First, a transitional period, and two, a support fund, and three, a consultative process. Security needs to be made part of our city's DNA, and make security an opportunity for our firms to upgrade themselves so that security and development can reinforce each other. In this new era, we have to bear in mind the strategic dimension of cybersecurity, and let's also be mindful of the anxieties of SMEs. We want security. We also want to be mindful of the social costs of workers potentially losing their jobs. The FTU cares deeply about this bill. We want resilience from this bill. We also want this bill to be something that drives social progress. I so submit I support this bill. Mr. Robert Lee. Thank you, President. I was a member of the Bills Committee. I support the Protection of Critical Infrastructure's Computer Systems Bill. This bill seeks to protect the computer systems of critical infrastructures without creating unduly onerous costs on operators. Technology moves fast. Critical infrastructures increasingly rely on the internet and cyber systems. Banks, power plants, and other critical facilities may be undermined or compromised by cyber attacks, and that will affect a city's operation and people's lives, and that will undermine the economy and even undermine public security, and that may end up hurting national security. We had some cyber incidents. So I support this legislation. Operators of critical infrastructure should be required to protect their computer systems, and they should inform the authorities once a cyber incident happens. The bill sets out 8 specific sectors. Banks and financial services are one such sector. Their critical infrastructures may be covered. In regulation, the government explained that the Hong Kong Monetary Authority will be a designated authority, so all financial institutions or FIs currently regulated by the HKMA will remain under the HKMA scrutiny if they are designated as critical infrastructure operators. And then there will also be the Commissioner's Office keeping an eye on FIs not under the HKMA's purview. The FCFC and the HKEX will not be designated authorities. The CCASS will not be a critical infrastructure. I made a suggestion during the BC's deliberations. Once we designate the CI operators, we should give time to the operators to prepare so that they can meet the future statutory requirements. An operator, once designated as a CI operator, will be held liable. That will be an entirely new liability for operators. They lack experience. I also support the approach that we take an organization-based approach rather than targeting specific individuals for CI operators. Businesses will be affected. The management of their infrastructures may be outsourced to third parties. When an operator contracts out the management of the critical infrastructures, will not spare that operator the responsibility to keep this infrastructure safe. So we need to make sure that those businesses do not just pass the buck to their contractors, and we have to explain to those third-party contractors, we have to tell them about the legal risks. Much about the details of the new law will have to be explained to the public. So after the bill's passage, the government should explain how the bill works to businesses of all sizes. And let's also clarify the scope of the bill. We're simply focusing on the critical computer systems of critical infrastructures. If it's simply a technical malfunctioning, not a cyber attack, or simply a problem with a mechanical fault or fault with the cyber system, those incidents fall outside the scope of this bill. I support this bill. This bill will prompt operators to build resilience. They will keep their computer systems safe and ensure the systems run smoothly. I so submit I support the bill.
Mr. Benson Loh. Thank you, President. I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. I am a member of the Bills Committee and I was involved in the scrutiny of the bill. The bill seeks to protect the security of the computer systems of Hong Kong's critical infrastructures. 8 sectors are involved: energy, IT, banking and financial services, telecommunications and broadcasting services, and so on. Operators of such infrastructures are regulated. All over the world, sizable organizations are subject to the cybersecurity attacks. the risk of CIs is also escalating. CIs are the lifeblood of the economy as well as social development. Their normal operation is key. Hong Kong is an international financial center. The security of CIs as well as their stability are the key to success. The implementation of the ordinance will help Hong Kong to create an even more reliable and favorable business environment, thus attracting even more people from all over the world. I'm a member of the panel on security, and I have been following up on this bill all the way from the panel to the Bills Committee. At the start of the formulation of the bill, I sought clarifications from the administration. I asked whether the owners of the CIs would be subject to regulation as well. The stocks of the listed companies might be scattered. And for those holding the shares, some are passive investors. They are not involved in the actual operation of the listed companies. I thank the administration for listening to my views. In the scrutiny of the bill, only operators of critical infrastructures are subject to regulation. The administration adopts a pragmatic approach. I support the administration's attitude in this regard. I also pointed out that sizable organizations, operators, and owners might belong to the same group. Internal communication is more convenient in this case. For some companies, there is not so close as a relationship among owners and the operators or the management of the CIs. It is fortunate that the administration once again clarified that the purpose of the bill seeks to regulate the operators instead of the owners of critical infrastructures. I believe this will help with the implementation of the ordinance in the industrial and commercial sectors. I am particularly concerned about support given to the industries. Most of the organizations subject to regulation are sizable organizations. SMEs are less likely to be subject to the regulation. Despite more resources for sizable organizations in order to implement the ordinance, manpower is key. So I'm glad to see that the administration will provide appropriate training for employees of sizable organizations. I believe employees will be in a better position to grasp the idea of the bill as well as the code of practice. Overall, the protection of CI computer systems bill has clear contents. The code of practice is in line with the latest development of the industry. I believe with the implementation of the bill, Hong Kong as well as our country will be more stable, and international investors will be more confident about the business environment in Hong Kong. I so submit. Mr. Yim Kong, thank you, President. This bill is key to the critical infrastructure security in Hong Kong. Hong Kong is an international financial center. The security of CI computer systems is the lifeblood of the economy. It is very important. However, there are a lot of different cybersecurity risks. Last June, the flight display system of the airport authority had an issue, and the airport had to resort to using a whiteboard to display flight information. This has taken a toll on the reputation of Hong Kong International Airport. According to Hong Kong CERT, over the past 2 years, they handled a total of 20,000 cases, and there is an upward trend. There was no lack of hackers' attacks. These incidents show hidden dangers. The administration has the responsibility for plugging loopholes. More work should be done. There should also be more cross-boundary collaboration to enhance the efficiency of the protection of CIs. The bill has drawn reference from different jurisdictions, say EU, Singapore, as well as China. There's a lack of legislative framework, so we need to plug the loophole. The bill adopts an organization-based approach covering different sectors, say energy, IT, banking, and financial services, as well as transport. Other infrastructures for maintaining important societal and economic activities are also covered. There are 3 obligations categories. Category 1, 2, 3, organizational, preventive, and incident reporting and response. We need to enhance our resilience in a systematic manner so that we can rise up to the challenges in relation to geopolitics. I suggest that the administration plow more resources on the following fronts. 1. There should be more technical support provided for operators. The bill only targets large organizations, but smaller enterprises, say smaller data centers, might become a designated operator. They should enhance their technical configurations in order to meet the requirements under the bill. So I suggest more funds, resources, or training should be provided to smaller organizations. The purpose is to ease the pressure on them. On a different note, the government should also update the code of practice dynamically. The COP is not part of the bill, but then it is a key document. I suggest that the administration review the COP constantly. There should also be a consultative panel comprising different representatives from different industries to make sure that AI, low-altitude economy, should be covered. And these are new emerging industries. We need to keep pace with the times. There should be professional talents, audit talents. Enterprises will have to bear a higher compliance cost. There's a lack of computer system security talents. For some industries, procedures can be streamlined and requirements can be relaxed as well. There should also be more courses to be provided to attract more practitioners. The aim is to reduce compliance costs and enhance the efficiency of the ordinance. The transparency of the above mechanisms should be enhanced. We should also enhance the level of participation of the public. There should be 2 more representatives from the public on the appeal panel. Say there should be a representative from the Consumer Council. The aim is to protect Hong Kong people, to make the Hong Kong public confident about the ordinance. Protection of CI is key. I hope different sectors will provide support. I also hope that the administration will take on board the views from different industries, thereby helping Hong Kong to move towards a smarter city so we can move from stability to prosperity. I also submit I support the bill. Thank you.
Mr. Rock Chan. Mr. President, I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. 4 years ago, the U.S. oil pipelines were subject to cyber attacks. Power supply came to a halt. 4 states were emergency state were declared for 4 states. Now that demonstrates the importance of protecting critical infrastructures. Now we are an international aviation and financial center. We are a city of data. We must not treat this potential cybersecurity threat lightly. There is an urgent need to enact legislation to protect critical infrastructures and the computer systems. The financial institutions and banks in Hong Kong also face such threats. According to the report published by the SFC, between 2021 and 2024, there were altogether 8 major cybersecurity incidents involving the sector. hackers were able to get their hands on the client's data, and that was followed by unauthorized transactions. Now, the Hong Kong Monetary Authority has a statutory function of regulating the financial institutions in the banking and financial services sector. But at the moment, the focus is only on the banking sector, but not the overall financial sector. In order to assess the security of the whole sector and the resilience, the Hong Kong MA should collaborate with the insurance authority so as to design the necessary stress test for the financial services industry. Under the guidance of the Commissioner, the relevant stress test and the scope should be defined. We can make reference to the Hamilton series in the US. The drills are led by the US Treasury, and the drills target various simulate various cyber attacks on financial services in the US, such as the stock market, payment systems, as well as the exchange. Apart from enhancing the security of the financial sector, the bill also it put in place incident response mechanism and restoration services or recovery services. At the moment, we rely on individual organizations to back up their data, and we should make reference to the safe harbor plan. That means in the event of any cybersecurity incidents, clients' data can be recovered effectively within a short period of time. This can help minimize the impact, bolster our status as as an international financial center. Now, it also means a lot to protect critical infrastructures for the sake of our society as a whole. For example, land, transport, and aviation, these are important sectors. We are an important regional hub. If the computer systems of these infrastructures are under attack, there will be dire consequences. For example, earlier, the flight system of the airport was suspended because of an attack, and that caused a major consequence. Well, of course, everything would come to a standstill. It would be chaotic. And if the railway system is under attack, then likewise, there could be collisions. And if the tunnel's operation is suspended, the traffic network will be paralyzed. As pointed out in the bill, the aviation or air transport and land transport comprise infrastructure for continuous provision of essential services in Hong Kong. And prolonged suspension or disruption of these infrastructures will substantially affect the normal functioning of society. So we need to protect these infrastructures. Apart from guarding against external attacks, the government should also step up its efforts to guard against internal system errors and human errors. That means we should avoid loopholes in computer systems being exploited by hackers. A minor error of a system operator could lead to dire consequences. We have experienced such similar incidents. For example, you may recall at the teething stage of the commissioning of the tunnel toll plans and the Hong Kong e-toll, the old toll schedules were used, and that caused some errors. And another incident involved the polling day for the district council elections. There was a malfunctioning of the voters register, and many voters were unable to vote until after 7:30 in the morning. The government should seek to plug system loopholes. That means there should be system security risk assessment as well as audits. We should harness AI technology so as to identify and plug loopholes and further enhance the protection of critical infrastructures. I support the bill and the amendments. Mr. Yu. Mr. President, I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. I'd also like to thank the administration and the government departments for their hard work during the deliberations of the bill. This bill is enacted against the backdrop of escalating cybersecurity risk in the global landscape. It is very important in safeguarding the social security and economic development in Hong Kong. Enhancing protection of critical infrastructures will ensure that normal functioning of society and people's livelihood will not be affected due to cyber attacks. The financial systems, transport networks, healthcare services, energy supply, etc. These are all infrastructures very much relying on the operation of computer systems, and these computer systems are often subject of cyber attacks. The disruption of the operation of these systems would cause substantial impact. It may also even endanger the lives and properties of the people. Now, many countries have experienced such incidents. For example, because of ransomware attack, an airline company incurred the loss of several billion US dollars, and there were also major power outages in some cities because of cyber attacks. It's not a computer or technical issue. It is a core issue that would affect a country's security and economic stability. Hong Kong is an international financial center. It is also a trading center and an aviation hub. There is a need to put in place an effective legal framework to protect critical infrastructures in Hong Kong. There is an urgent need to do so. The object of this bill is to enact a comprehensive framework to protect the security of computer systems of critical infrastructures. The bill also imposes on operators of critical infrastructures 3 categories of obligations. The first category is organizational obligations. The CIOs are required to set up dedicated management unit so as to step up its resilience against cyber attacks. That's the second category, called preventive obligations. The third category refers to incident reporting and response obligations. That means in the event of incidents, the matter should be reported to the Commissioner's office within a certain time frame. This can help enhance the resilience of computer systems, of critical infrastructures in Hong Kong, and minimize the impact on our society and our economy. I'd like to highlight a few of my concerns in the implementation of the bill. I hope that these problems can be solved and that improvements can be made. The first point relates to the extraterritorial effect of the bill. At the moment, it does not carry any extraterritorial effect. For computer systems outside of Hong Kong, especially for systems supporting the core business that happens in Hong Kong, this bill presents some constraints because this bill does not cover these systems out of town. The government should further consider how this bill could tackle cyber attacks from outside the territory. We should also explore options such as setting up a coordination mechanism with the mainland. The second point is that in the event of a serious cybersecurity incident, the CIOs are required to report the incident to Commissioner's office. Now, that includes material changes as well. However, nowadays, computer system upgrades happen very frequently. This may add to the compliance burdens of CIOs. The bill the codes of practice in the future should spell out what material changes mean. For example, whether material changes only entail, for example, changes in the core modules or the core structure of the computer systems. A flexible approach or a tiered approach should be put in place to lower the administrative burden of operators. Technical support should be provided to CIOs to determine whether there is a need to report to the Commissioner. My third point is about regular computer system security drills. Operators are obliged to take part in the regular drills, or else they would be breaching the law. The purpose of drills is to help operators identify loopholes. The purpose is not to penalize them. Now, for operators underperforming during the drills, will they be taken into account? The COPs should clarify the position in the future. For problems exposed and identified in drills, the CIOs should come up with a remedial plan rectify the problem as quickly as possible. The Commissioner's Office should also provide technical guidance proactively to CIOs to enhance system security. Now, the establishment of the Commissioner's Office is 30 to 40, but in terms of workload and the scope of duties, I'd say that the current proposed establishment will not be sufficient in coping with the workload. Apart from the professional capability of the commissioner, the government should also review the manpower resources devoted on a regular basis and provide suitable additional manpower and technical support. For other relevant organizations such as the SFC and the Hong Kong Airport Authority, the government should consider including them as designated authorities as well. This is an epic battle. We need to position ourselves at the more favorable point. This is done by enacting this piece of legislation. It will provide an effective tool for us to cope with the ever-changing cybersecurity threats in the future. I support the bill. I hope that in drawing up the COP, the government will continue to heed the views of sectors so that this bill will remain effective and help protect the critical infrastructures in Hong Kong.
Mr. Kenneth Leung. Thank you, President. When the technology is evolving, computer systems is important not only to our lives, but our society and its operation. Critical infrastructures, such as financial systems, when they are attacked, it will put our society to a stop, and it will threaten people's lives and property. So in order to ensure the security of critical infrastructures, we have to implement this bill. So I speak in support of the Protection of Critical Infrastructures Computer System Bill to regular critical infrastructure to make sure that relevant operators adopt means to protect their computer systems to minimize the impact caused by computer attacks. President, computer system is one of the most important tools. Some cybersecurity companies said that in 2024, we saw the most frequent cyber attacks. And we will see increase in the number of cyber attacks in the future. In 2025, in the forecast of the APEC, it is said that given the heightened geotechnical political tensions, it will pose threats to critical infrastructures over the world. The critical infrastructures will be the targets of cyber attacks. The relevant organizations in Hong Kong also pointed out that the cyber attacks are targeting critical infrastructures increased. Local hospitals and tertiary institutions were subject to ransomware attacks. So I think that the government needs to plan ahead and protect our computer systems and critical infrastructures. Having made reference to other countries and places, we see legislations. For example, in our country in 2021, we already have the regulation on protecting the security of critical information infrastructure. In the European Union and Singapore, there are also relevant legislations protecting their critical infrastructures. So we think that by having this bill is necessary. The bill covers 8 major essential services and infrastructures. When the operators are being designated, they have to manage their system, manage their risk, and make reports of relevant incidents. I think that the responsibilities of the operators are well set out under the bill, and this will encourage the operators to enhance their cybersecurity level. The bill has struck a balance among the interest of different stakeholders. The reporting timeline for serious threats has been lengthened to 12 hours. For other incidents, the time for reporting is 48 hours. This will allow the operators to make reports to the government in time and seek help. President, one of the other major points under the bill is for the chief executive to appoint a commissioner and to establish a commissioner's office under the Security Bureau to carry out the relevant duties. The commissioners is empowered to investigate and help the operators carry out their duties. The commissioners will issue code of practice, offer technical guidance, and offer support. They will also give written guidance to the operators. The commissioner's office will also organize drills to make sure that the operators are ready in face of threats and incidents. The commissioners is very important. He is a facilitator and a supervisor. They will help the operators play their gatekeeping role so that our critical infrastructures will be better protected. President, the threats of cyber attack see no boundary. We have to protect our cybersecurity information systems. We have to enhance their resilience against cyber attack. So I support the bill. But after the bill's been passed, I hope that the government will explain and promote the bill so that members of the public understand the importance of it. The bill does not cover government departments, but say, for example, water supplies services are offered by the government. So I think that the departments should enhance their transparency. They should work with the commissioners and enhance the reporting mechanism. The bill is to solve the threats that we face. So I think that the advice of the commissioners and the code of practice should cover the training for relevant personnel so that they can cope with the threats and make the right choice when they're in face of an incident. Also, we need to enhance and nurture more talents on the relevant fields so that we can safeguard and security of our computer systems. I also speak in support of the bill. Thank you. Mr. Siu Ka-fai. The Liberal Party supports the Protection of Critical Infrastructures Computer System Bill. As we all know, we've seen a lot of online scams, and for businesses, we've seen blackmail happening, and after the hackers have attacked the website of a company, they would lock their information up and blackmail them into paying ransom money. This relates to the private sector, but for large-scale infrastructures, say for example the airport, the MTR, hospitals, they're not about an individual company, but the interest of the entire society. 25 years ago, I watched a movie called Die Hard 2. The story goes like this. It's about a group of terrorists taking control of an airport system so that a number of aircraft could not land or take off. They have some political requests, and in the end, because the network was being controlled, an aircraft exploded. It may sound like a mere story, but if a group of terrorists actually take control of the airport system, that would threaten the security of our people. As an assistant of mine, some years ago, went to work for the MTRCL, but he or she resigned. And they told me that they were driving the train. And they said that they were only responsible for opening and closing the doors of the train. They were not really driving the train. The system does. As you can imagine, if the MTR system is being taken control of by malicious people, then the consequences could be dire. So I think that the Security Bureau should have regular communication with operators of critical infrastructures to make sure that they comply with the law. I hope that there will be a better set of standards so that the CIO would update their safety standards to better safeguard the safety of our people and our national security. So our party supports the bill. Some people may have different views. Hong Kong is an international financial center. I was talking about critical infrastructures for stock market. I don't know if they will be included as in critical infrastructure, but if they are compromised, then that would affect our position as an international financial center. Former Legislative Counsel Mr. Charles Mock, said on an online newspaper of the U.S. that by having this bill, and if it's passed, it will affect the operation of the SMEs and there could be privacy concerns. I believe that this bill will help the SMEs in Hong Kong. If our critical infrastructures is not well safeguarded, and if the data of the people is leaked easily, then that would undermine our business environment. Some people are not familiar with the content of the bill, and they try to smear us. I hope that they will not continue with the random things that they say.
Mr. Su Cheng-Wing. Thank you, President. I speak in support of the Protection of Critical Infrastructures Computer Systems Bill. Technology develops in leaps and bounds. People's lives, their work are related to computer systems. Computer systems is an essential and indispensable part of every area of our lives. Say, for example, information technology, financial transactions, and transportation. These systems brings efficiency. At the same time, there is an over-reliance of these systems which gives rise to threats. There are hackers, there are cyber attacks. It is not uncommon to hear about these incidents. They cause infrastructures to be disrupted, which in turn affects people's lives. Legislating to protect the computer systems of critical infrastructures, CIs, is the duty of various parties in different countries. This is an important piece of legislation. the US, UK, Australia, Singapore, the mainland, Macau, they have similar legislations put in place. Hong Kong is an international financial center. We are seriously affected by geopolitical factors. We are susceptible to cyber attacks. When it comes to legislation, we seriously lag behind other jurisdictions. The government said that with the passage of the bill, within a year, a commissioner's office will be set up so that the ordinance will take effect in a half year after the office has been set up. I fully understand the urgency of protection of these systems. I hope that the establishment of the office can be expedited as much as possible so that the law can take effect soon. There are 3 principles that must be upheld. First, the paramount importance is on national security and the maintenance of daily lives of the people. We see intensifying international relationship. Hong Kong may be attacked from overseas on the internet anytime. The Commissioner's office should be fully prepared to tackle incidents that would disrupt our lives and our national security. They should have the capacity to handle all kinds of situations. There should be power given to the Commissioner's office. The office is headed by a commissioner. The office is under the Security Bureau. It may not be a high position, but the position requires the cooperation of major corporations. These corporations may be reluctant to disclose necessary information for concerns of trade secrets. The commissioner may in the end up being a toothless tiger. It may not have the clout strong enough to implement the regime. Support should be given to the infrastructures. The administration said that the regulated parties will be major corporations. They may be major corporations, but they may not be fully alive to all information or the best solution to handle situations. The government should support them with information. Otherwise, the objective to protect critical infrastructure may not be realized. Under the bill, the regulation is done under an organization-based approach. Operators act as a unit in the fulfillment of their obligations, and these obligations include obligations on organization, on response, reporting, and prevention, but they may not have the capacity to act in accordance with their functions. Hackers may attack non-government organizations for monetary benefits. They may do it as a prank. Whatever it is, it will bring serious disruptions. International situation changes rapidly. It is uncertain and unpredictable. The government should not underestimate the risk of cyber attack. These attacks may aim to disrupt our financial system, our public transportation system, and there may be malicious ulterior motives involved. The government needs to set up a regulatory framework. Within the government, preventive measures should be put in place. The Security Bureau should keep in touch with their counterparts in our country and other jurisdictions. They need to work together to form a system to handle and prevent threats. Training should be provided to groom a pool of talents so that threats coming from AI and other forms of technology can be efficiently handled. Next, Mr. Lai Chong-kwok. President, I speak in support of the bill as well as the government's amendments. There is expedited digitization of the different systems in the world. Issues are now more complicated. Different parts and different realms of society are easily affected. Jurisdictions all over the world legislate to protect their critical infrastructure and computer systems to ensure that society will function normally, to ensure that people's lives are not affected. The Chief Executive in his policy address in 2022 that we need to legislate to protect critical infrastructure. A new important bill covering an extensive area will be introduced. The government spent a lot of time to analyze, to consult. In the end, the bill was gazetted at the end of last year. The Bills Committee spent 1 month using 4 meetings, each lasting 4 to 5 hours on the bill. A total of 17 hours was spent on the scrutiny of the bill before its completion. I thank the leadership of the chairman of the Bills Committee. I also thank officials for listening to our questions, giving us detailed answers, and their thorough consideration of our views. The bill has an extensive scope. There is room for improvement in individual areas. That's why I support the government's amendment. I will now move on to suggestions from me that are accepted by the government. In the last Bills Committee meeting, I pointed out that if the bill is passed, the Commissioner will have extensive power. The powers will be greater than the designated authorities. The Commissioners, the last say should be vested in the right party. The Secretary for Security has explained to us, has given their explanations. My suggestion transformed into an amendment. The Secretary will not give directions to the Commissioner for the sake of it. The obligations, the duties and rights are clearly delineated. The Secretary may give directions to the Commissioner as necessary to better enforce the bill. In 8.3b, 5b, as well as 7.3, is mentioned about the publication of notices. That is in relation to the direction. And the reference of bringing the publication to the attention of those that may be affected. Well, those who needs to be informed are those who have to abide by the code. So I suggested to the government that the reference should be made more concise. As a result, the government moves to amend A3B1, A5B1, and A7 A to make the reference more concise. In relation to clauses 11 to 13 and 55, in relation to the specified matters in ascertaining critical infrastructure, operator and systems, there is the basket of factors to be considered. These may cover many different issues, but there is a word of may. It means that it may not be considered. As a result, I suggested to the administration to clarify the provision. I thank the Security Bureau for taking on board my suggestions to replace the word may with must, so that these factors will be carefully considered. And there is a similar situation in clause 53. Along the same vein, I asked the government to consider amending it. I'm glad to hear that the government has accepted my suggestion. In clause 19, there is a mention that the CI operators should maintain an office in Hong Kong. But in context, there may be people may be misled that as long as the office can receive correspondence, that will do. There is no requirement to run a physical office in Hong Kong. Questions were asked in the Bills Committee. The Security Bureau clarified that it was not their intention. The original plan was that the suggestion of maintaining an office will be left to the Code of Practice. But the Code of Practice is not a piece of legislation. If there are challenges, then we'll have to refer to the law. I'm glad to see an amendment which makes it clear that CI operators must maintain a physical office in Hong Kong that is occupied by the operator for carrying on its business. I expressed concern about the implementation of the bill. Currently, there are only 2 designated authorities. There are other authorities with a function similar to those 2, say the MPFA as well as the Insurance Authority. The member organizations use a large number of computer systems. I urge the administration to consider specifying them as designated authorities. I understand that the administration needs to consider a number of factors in the specification. They need to consider whether these organizations are critical infrastructure operators. Using the MPFA as an example, the MPF is an important retirement protection. If individual organizations make mistakes or encounter incidents, it is a major incident. The commissioner may not know more about the field than the MPFA. I asked the administration to first consider specifying the MPFA as a designated authority in the future review. The number of specifications will affect the efficiency of the office. I understand that there will be more than 11 people in the office, that is, apart from the number of directorate posts as well as permanent posts. There will be staff members seconded from the Digital Policy Office as well as the police. It will have a strength of 30 to 40 people. But I think that they will encounter operational difficulties. If there is a manpower shortage and they need to do further secondment, it will put more pressure on themselves. So if they can absorb more experienced authorities as designated authorities, then the work can be shared. I so submit.
You.
Mr. Ma Fung Kwok. for the protection of critical infrastructure. I am actually a member of the Bills Committee. I have seen how the administration has worked with different stakeholders to derive the bill. It is an important step towards protection of critical infrastructure. It also demonstrates how much we value this. And computer systems are now core to many different facilities, say transportation and healthcare. If these systems are attacked, it will affect the stability of society, and worse, it may hurt the property and safety of the public. In fact, last year, an academic institution was attacked and much of the personal information was leaked. According to data provided by a center, we had before 7,000 cases in many years before. We now have over 10,000 incidents a year in the year of 2024. So having a framework to ask critical infrastructure operators to protect their systems is necessary. During public consultation, we have received feedback that support the proposals. Most of them are supportive. Some object, seem to quote ridiculous reasons or to advance their personal interests. In fact, such regulation is found regularly in many jurisdictions such as mainland China, US, UK. They have relevant legislation, and the administration has referred to the practices of other regions to make sure we can tie in with international standards. And specific rules of the framework refer to the framework in the UK and Europe. It says in the framework for large-scale operators, if they are charged in court, their identities will be exposed, and then they may suffer a damage to their reputation. I believe the administration's proposals have struck a balance. During the deliberations of the Bills Committee, the members discussed different aspects of the bill. For example, how we can balance comprehensiveness and operability, and how to prevent an overly large burden being imposed on small and medium-sized firms. Over 10 odd hours of discussion, we have discussed different aspects, and the administration has accepted some of the suggestions made by members of the Bills Committee. For example, to provide more support, technical support to operators to conform to the relevant requirements. And it seems that in previous incidents, companies are often very confused, and they would need some time to deal with the information, and before we're supposed to be made within 2 hours. The administration has heeded our feedback and extended it to 12 hours. This is actually lesser than that in Singapore and Macau, but is on par with that in Australia. So that should have struck a balance. Often, third-party providers would be engaged to provide services, so there's the issue of accountability. And we thank the administration for clarifying that the responsibility cannot be outsourced by the operators to the third parties. The administration will also promulgate codes of practice for the reference of operators, and valuable feedback has been given by members. I hope the administration can compile a comprehensive set of guidance so as to minimize confusion. It says that every 2 years, operators would have to take part in drills organized by the Commissioner's Office. I hope that with the drills, it would enhance the capabilities of operators to respond to incidents and improve coordination among different parties. This is an important issue. The bill will just be a starting point. In future, we need to enhance public education and enhance public awareness towards cybersecurity. It is only with concerted efforts that we can construct a safe online environment. I so submit, President Dr. Simon Lee. President, I would like to speak on the bill. I will talk about the global trend, challenges faced by Hong Kong, and regulatory frameworks in other places of the world. Faced with an increasing threat, Hong Kong has to do more in information security. We now have critical infrastructures and computer systems because technology is playing a bigger role in systems now. In 2024, there were 12,000 odd incidents of computer system security. And we have now 62% of the cases being cybersecurity attacks, and that is a year-on-year increase of 108%. With the development of AI, we have seen the speed of attacks increase by 7-fold. We need to raise concerns on the protection of critical infrastructures with the rise of such challenges. Hong Kong has a special position, and therefore there is a greater demand for protection of computer systems and critical infrastructures. We have 3 types of vulnerabilities. Hong Kong as a hub, a financial center, deals with many cross-border payment, trading, and stock market transactions. When something happens, there may be a domino effect. In terms of system protection, it is fragmented at the moment. The protection of personal data ordinance right now only covers personal data. Seeing Hong Kong as a hub, there is really a need to enhance protection of critical infrastructure. It is what is needed at these times, and it is what is needed for Hong Kong. With globalization, we have seen in other places that there are regulatory frameworks on protection of critical infrastructures. In 2018, the EU has promulgated regulation of critical infrastructure, and fines would amount to 4% of company revenues, and it would amount to some hundreds of billions or so billions of dollars in fines. The US has also suffered multiple attacks. In Singapore, there is an authority called CSA that would ask for reports to be submitted on simulated attacks to be submitted. If we lag behind in protection, people may not be as confident in the stability of operations in Hong Kong. It is not conducive to Hong Kong's long-term development. I think the bill's proposals have struck a balance in the sense that it has protected critical infrastructure without impeding development. We have now an effective relationship that would not only protect data, but also lessen the impact on companies. We have delineated clearly the scope of protection. We have for energy, finance, and healthcare. We have a two-tier designation. I believe this approach is a reference to the US system. We have also covered some information technology and financial services, say for the side report, some annual reports to be submitted. It should be able to cover the new trends so that we can keep abreast of the times. We also have a dual-track regulatory regime that would lower the compliance costs. We need interdepartmental coordination to deal with the relevant risks, and with designated authorities in the specific industries, they can specify the specific requirements for the industries that has minimized the cost by not adopting an across-the-board approach. We have the government providing subsidies to those firms that need such. There are also exemptions that may be granted to small and medium-sized firms. In implementation, we may need to specify more details, such as the qualifications for the designated personnel and for the operators. There may need to be more specifications. This is something we can think about in future. This bill would act as a moat to protect our critical infrastructures. The computer systems need a statutory framework for their protection. It is of paramount importance that we protect the critical infrastructures. The bill has balance, security, personal data protection, and costs. It is a bill that has considered the needs of Hong Kong. There are also support measures for firms. There is also an appeal mechanism. This bill is very meaningful. In future, I hope the government can make sure there are administrative arrangements to actually protect the critical infrastructures. I would say this bill will not place a chokehold on the development of a city. It is in fact helping us take the next step. It has incorporated EU and Singaporean standards. It has made sure there is a safety net for Hong Kong while not impeding development of Hong Kong. I speak in support of the bill for the healthy development of Hong Kong.
Mr. Lee Chen-kan, President, we are here to discuss the protection of critical infrastructures computer system. There are two types of critical infrastructures. First, energy, information technology, banking and financial services, air transport, so on and so forth. All these services are highly related to people's livelihood. We have mobile phones, we have computers at home, in our offices. We come across such services on our day-to-day life. The second type of critical infrastructures are ones that maintain critical societal and economic activities, including performing venues. They include places for people to watch art performances. They are also covered in similar legislations overseas. As a lot of members have said, we have made reference to the Australia, UK, EU, Singapore. they have similar legislations. For critical infrastructure operators, we subject them to 3 types of obligations: organizational, preventative, and incident reporting and response obligations. The bill mandates the operators to report to the government about major cybersecurity incident. For these serious incidents, they have to make a report to the government within 12 hours. For other incidents, they have to make a report to the government within 48 hours. So in terms of penalty, we have also made reference to the similar legislations in the UK and EU. The maximum fine is $500,000 to $5 million, and an additional daily fine of $50,000 and $100,000. So why I mention this? What I'm trying to say is that we did not come up with this bill on our own. We have made reference to other major economies. We have tailor-made this bill to suit Hong Kong's situation. I'd like to commend the administration. They said that the CIO can outsource the work to a third party, but the responsibility cannot be outsourced. This is key. We should not allow the operators to pass the buck onto the third-party contractors. We should not outsource our responsibility of protecting critical infrastructures. Now, on the code of practice, I hope that the administration, when they formulate the code of practice, will consult the trade. Now, the bill asks the operators to hire someone with a relevant knowledge to manage the system. They also have to engage independent auditor to perform auditing of the firewalls, for example. How do we come up with the criteria of qualifications? Should we work with overseas bodies? Should we ask these personnel to undergo examination? If all the operators have to engage such professionals, it will be difficult for everyone to hire these talents. Can different operators hire the same manager? Or can they outsource the service to a contractor? I hope that the administration will give us an answer to this. My last point. Some people, unfortunately, could not make a report in time, and they were subject to investigation. The administration have to obtain a warrant from the magistrates in order to obtain relevant information from the operators, and the time taken to obtain a warrant could be quite long. And when that happened, I'm worried that the relevant data, due to various reasons, would disappear. So in the code of practice, or in actual operation of the bill, I hope that there will be a flowchart to speed up the process. Without security, there won't be development. So I fully support the Protection of Critical Infrastructures Computer System Bill. Thank you, President. Dr. Louis Long. President, the operation of critical infrastructures rely on the internet and computer systems. In recent years, there have been multiple attacks against our computer systems and infrastructures. When the computer systems of critical infrastructures is attacked or damaged such that they cannot offer normal services, that will disrupt the normal operation of various trades, and it will affect people's life. Hong Kong, as an international financial center, should have a comprehensive legal framework to protect our critical infrastructures as well as their computer system. The policy goal of this bill is to enhance the security of the computer systems of the critical infrastructures to minimize the extent of impact caused by the disruption to the computer systems and to enhance our resilience against any risk. I think that is necessary for us to legislate, and there is an urgent need for it. The bill will enhance the resilience of the computer systems to make sure that the society can function normally. It will also create a more favorable business environment, consolidate our international position. In terms of the scope of regulation, the bill covers two major critical infrastructures. First, infrastructures for continuous provision of essential services. They cover essential services of 8 groups. The second type of critical infrastructures are those for maintaining critical societal and economic activities. Once these infrastructures are damaged, that may affect critical societal and economic activities. The government said that in order not for the critical infrastructures and the operators to become targets of attack, they will not announce the list of operators and infrastructures. I understand that. The government has taken on board the views that they collected during public consultation. Owners of critical infrastructures may not participate in the operation of the computer systems, so under the bill, owners will not be held liable. The bill only regulates the critical infrastructure's operators. I support such an arrangement. According to the paper submitted by the government to the LegCo, the bill does not cover the government. However, the government departments must comply with the security regulations and the government information technology policy and guidelines. The Digital Policy Office will regularly conduct compliance check on departments that are facing the public, and they will also audit the systems of relevant computer or government bureaus and departments. People are worried if the government will only be strict on the public but be lenient towards their own departments. So I think that the various departments and bureaus must keep in close liaison with the DPO. There should not be any double standards. Under the regulatory framework, the CIO have 3 types of obligations, including organizational obligations, preventive obligations, and incident reporting and response obligations. The bill says that the chief executive can appoint a commissioner for critical infrastructures, computer systems. As the monetary authority and the communications authority already have relatively mature regulations over the financial sector and the telecommunications sector, and they are the most familiar with the relevant regulations. So the monetary authority and the communications authority will regulate the banking and the financial sector, as well as the telecommunications industries, respectively, regarding the Category 1 and 2 obligations. As for Category 3 obligations, that will be under the purview of the commissioners. I think that this division of duties is appropriate so that there will not be any duplication of efforts. Regarding Category 3 obligations, that is incident reporting and response, according to the consultation paper, for a serious incident, the operators have to make a report within 2 hours. Trade practitioners think that the time limit is too short. Under the bill, the time period has been extended for serious incident 12 hours, other incidents 48 hours. I think that this change is a response to the concern of the trade, and a balance has been struck. The bill empowers the administration to issue a code of practice to set out standards and actual guidance for the operators to comply with categories 1, 2, 3 obligations. As the first type of critical infrastructures cover 8 different kinds of services. I hope that the government will take into account the actual situation of different service providers and set out clear guidelines in the code of practice. And I hope that the code will be updated regularly to keep them in line with international practice. I think that the bill, together with a code of practice, will be a very flexible approach, as this bill is not in legislation regarding information systems. If the hacker only steals information but does not damage or destroy the computer system, that's not covered by the bill. If leakage of personal information is involved, the CIO have to make a report to the Privacy Commissioner's Office of Personal Data and the Administration Commissioner's Office. There is not a mandatory reporting regime for leakage of personal data currently. I think that this situation is not ideal. Now, the Secretary for Security has submitted this bill to enhance the protection of computer systems of critical infrastructures. Well, another policy bureau of the government is looking into amending the PDPO for some years. However, they are not able to offer a timetable when they come to electrical meeting in February. So I hope that the government will amend the PDPO as soon as possible to establish a mandatory reporting mechanism and to put in place a penalty for leakage of personal data. I so submit. I speak in support of the bill. Thank you.
Does any other member wish to speak? If not, I now call upon the Secretary for Security to reply, then the debate will come to a close. President, first of all, I'd like to thank members for their valuable views and support for the Protection of Critical Infrastructure Computer Systems Bill. Critical infrastructures, CI refer to infrastructures that are necessary for the maintenance of normal functioning of society and normal life of people. The bill aims to impose statutory requirements on designated CI operators to ensure that appropriate measures are put in place to protect their computer systems and minimize the chance of essential services being disrupted or compromised due to cyber attacks, thereby maintaining the normal functioning of Hong Kong society and the normal life of people. This is conducive to enhancing the overall computer system security in Hong Kong. The bill proposes to establish a commissioner's office under the Security Bureau to take charge of the new law. In relation to today's legislative work, we started the first round of consultation in 2023. We have held over 15 consultation sessions to collect views from stakeholders, including potential designated CI operators, computer system security service providers, chambers of commerce, and professional bodies. In July last year, we consulted the electrical panel on security and commenced a one-month second-round consultation. The proposed legislation was widely supported. In October last year, we reported the results of the consultation to the panel. Before the bill was introduced to LegCo, we had briefed major chambers of commerce and stakeholders overseas and in Hong Kong on the consultation report. When we had in-depth discussions with legislators during the scrutiny of the bill, our team also conducted the third-round consultation with the sector. We had further exchanges with potential designated CI operators to discuss the framework of the Code of Practice, COP. We are happy to see the positive response that recognizes the need to legislate from stakeholders and the general public. After the first reading of the bill on the 11th of December last year, the Bills Committee has held 4 meetings in January and February, spending close to 17 hours on the scrutiny. In-depth discussions were conducted on the policy intent, views of the sectors, and law drafting, etc. Members have made constructive comments. A report that supports the resumption of second reading debate was made to the House Committee on the 21st of February. I'd like to take this chance to express my heartfelt gratitude to the Chairman, Ms. Carmen Khan, members, the Secretariat, and the legal advisor for their hard work that enabled the efficient scrutiny of the bill. I also thank deputations for their submissions to the Bills Committee. Subject to the passage of the second reading, I will move 31 amendments. The amendments have incorporated the valuable views of the Bills Committee to improve the drafting of the bill and the clarity of the provisions. I will elaborate in the committee stage. I would like to take this chance to emphasize once more the legislative principle of the bill. As mentioned on a number of occasions in the Bills Committee, the aim of imposing statutory obligations is to protect the security of computer systems that are of utmost importance to the core functions of CIs and not to target personal data or trade secrets. If the regulating authorities in the performance of their duties need to obtain information from operators or relevant organizations, they must exercise this power to request information in a reasonable manner, comply with the conditions and procedures provided for, and only request information that fulfills the purposes of the relevant provisions. In addition, there are provisions that strictly regulate the disclosure by officers of matters which come to their knowledge in the performance of the functions. Regulated CI operators are those that are necessary for the continuous delivery of essential services or maintaining important societal and economic activities in Hong Kong. They are mostly large organizations. Small and medium enterprises and the general public will not be regulated or affected. I would like to stress again that the bill has no extraterritorial effect. Regulating authorities cannot enforce the legislation outside Hong Kong. However, in this day and age, information network has no boundary. Many organizations in Hong Kong frequently use servers outside Hong Kong to store or support the core function of a CI. In other words, a system that is accessible by the CI operator in or from Hong Kong and is essential to the core function of a CI is regulated by the bill. But it does not mean that the legislation has extraterritorial effect. Regulating and imposing obligations on CI operators in Hong Kong is fully in line with the territorial principle. The bill stipulates that only CI operators designated and their computer systems designated as critical computer systems will be regulated. The bill adopts an organization-based approach, that is, using the organization responsible for operating a CI as the unit, which must fulfill its obligations in protecting the security of its computer systems. Upon designation, the operator must fulfill the 3 categories of statutory obligations, namely Category 1, organizational, Category 2, preventive, and Category 3, incident reporting and response. To implement the legislative regime, a commissioner's office will be set up under the Security Bureau to work with the 2 designated authorities to monitor the compliance by CI operators. At this stage, we propose to designate the Hong Kong Monetary Authority to monitor operators in the banking and financial service on compliance with Cat 1 and 2 obligations, whereas the Communications Authority CA is designated to oversee that of operators in the telecommunications and broadcasting sector. After the passage of the bill, the Commissioner's Office and the designated authorities will, in accordance with the definition of CI, ascertain if an infrastructure in the sector is necessary for the continuous delivery of essential services or maintaining important societal and economic activities in Hong Kong. They will then approach the potential CI operators for a firm grasp of their business operations and the computer systems on which they rely on to provide services to ascertain whether the potential CI operators and the computer systems fall within the related definitions under the ordinance before deciding on the designation. To assist operators with compliance, regulating authorities will issue a code of practice setting out the proposed standards based on statutory requirements. These include professional qualifications of the head of the Security Management Unit, examples of material change, details and standards of the Security Management Plan, risk assessment and audit, staff training, what constitute an incident, etc. The COP, which is not legislation, allows the flexibility of updating in a timely manner, taking into account the latest technology and international standards. The regulating authorities will also communicate with the operators of different sectors and include sector-specific guidelines in the COP where necessary. In the debate, some members suggested that the government consider specifying regulators of other statutory sectors as designated regulators in charge of monitoring and regulating the compliance of Cat 1 and Cat 2 obligations. We have explained to the Bills Committee that a number of factors come into play in the consideration of specifying a regulator. These factors include 1. The regulator's existing key functions, targets of regulation, including the number of potential CI operators, and power and scope of regulation. 2. Whether the regulator has issued guidelines on computer system security and the contents of these guidelines. 3. Whether specifying the regulator will be more effectively serve the purposes of the bill as a whole. We have fully considered these factors. In the bill, the Hong Kong MA and the CA are specified as designated regulators. Specifying other statutory sectoral regulators will not be considered at this stage. The government will review the list from time to time. When necessary, we will amend Schedule 2 by subsidiary legislation to specify other regulators. Just now, members suggested the inclusion of individual sectors, say for example tertiary education. We will take into consideration and consider that at the right time. We will, if necessary, amend Schedule 1 to increase the number of sectors. Regarding members' concern on how to ensure compliance by third-party service providers, and how to deal with non-compliance with requirements in the bill if the service providers located overseas are unable to comply due to conflicts with domestic laws of other jurisdictions. It is a common practice to engage third-party service providers to assist in the day-to-day operation. We must emphasize that the obligation cannot be outsourced. Even with a third-party service provider, the operator is still required to fulfill the relevant statutory obligations. Terms can be included in the contract to ensure that third-party service providers meet regulatory requirements. This is similar to multinational corporations' duty to ensure compliance in the place they operate. Regulating authorities will provide guidelines and contract templates in the COP, setting out the obligations and roles of these providers for operators to refer to. This will assist operators to ensure that third-party service providers comply with the law. Some members mentioned about the list of third-party service providers. The COP will set out factors and guidelines in relation to engagement of third-party service providers. At this stage, we will not consider making a white list. If the situation changes, we may further consider it. Some members suggest that the government should take over the operation of critical infrastructures when there are attacks. Let me stress that the policy intent of the bill is to impose obligations on CI operators to protect the computer system of CIs. When an incident occurs, the Commissioner will require the operators to take appropriate measures to respond. If necessary, the Commissioner will intervene to assist in recovery. The bill, however, does not cover any powers to take over the operation of the entire CI. It is not our policy intent. In relation to IT manpower shortage, according to our estimate, the number of graduates from tertiary education institutes in various IT programs stands at roughly 3,000 every year. The government will promote manpower training for the computer system security trade. This includes attracting talents from different places through the Quality Migrant Admissions Scheme and encouraging tertiary institutions to offer more IT security-related programs. President, our goal upon the passage of the bill is to put the ordinance into effect on the 1st of January 2026 and set up the Commissioner's office. The office will continue to engage with stakeholders. Taking into account the different state of readiness of potential CI operators, we expect to designate CI operators and critical computer systems by phases starting from the second half of 2026, that is mid-2026. President, I move the second reading of the bill. I ask members to support the second reading and the amendments I will move in the committee stage for the protection of security of computer systems of critical infrastructures in Hong Kong. I so submit. Thank you. And I put the question to you that the Protection of Critical Infrastructures Computer Systems Bill will be read the second time. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of members present. I declare the motion passed. Protection of Critical Infrastructures Computer Systems Bill. This council now becomes Committee of the whole Council to consider the Protection of Critical Infrastructures Computer Systems Bill. Members may refer to the appendix to the script for the debate and voting arrangements.